is regarding about bank. Your Lordship was there. I was not in this case, Punjab National Bank, where under the Assam Tea Corporation Limited had leased out. Ultimately, your Lordship has vacated the order and fixed it on 28th of January. So just we are making an IA, if it is possible, depending on the fact that immediately after reopening, because of the court, if your Lordship feels that there is some urgency after reopening.
Yeah, urgency.
Urgency means my lord, not of public money. It's a public money. Whether we are entitled or whether we are not entitled to recover that money. Because your lordship, what I have been told that's
You
indicated.
have entered into an agreement with a lessee.
That's your lordship is absolutely. I have your lordship give us that.
Your interest cannot further go beyond the
One my lord, there is a term loan. This is 2.40 and cash credit. Your lordship, I agree. There's nothing to do with the cash credit. But term loan is concerned, your lordship, right? There is an agreement with the ATCL saying that they cannot mortgage so far as land is concerned. Now the courts, what I felt, subject to what my instruction was that the court give us the leasehold property, what right you have got. That's what. Only just making a prayer, if it is not inconvenient, can it be IA can be listed?
You have fixed it when?
28th of January. 28. 28.
Tuesday.
I'm sorry.
The Tuesday.
Yes.
So lucky.
So can it be before only making a prayer? Is your lordship feels that no, it is not. So
no, before that, you see, first week only one day. Second week is almost packed out there. So many matters are there.
Your lordship, we just any date before 8, 9, whichever is convenient for your lordships.
Then we have this. Okay, you file your IA.
I have already filed.
Let those IAs come.
Yes, yes. Tomorrow it will come, my lord. Only your
Tomorrow.
Tomorrow to allow this IA. Or whenever it's probably reopening also. If your
Last day. Friday.
Yes. I'm with you. May I please
in supplementary item and 67 my lord. Supplementary item number 67. We file my lord additional affidavit by the respondent number 12, 13, 15 and 28. It may be called for my lord. Additional affidavit.
Has the person taken steps? The petitioner person, that is why the matter has come.
But we file additional affidavit. Additional affidavit.
Who?
Respondent number 12, 13, 15.
And that's okay. But the matter has come up because of the fact that he has not taken steps. I've asked them to change the memo parties, to file a fresh memo parties, which he has not. Okay, you want to bring them, bring them.
Okay.
Hey, His Lordship, I beg to mention item number 17. Can you list this matter after vacation?
Which one item?
17.
17.
Come for the petitioner.
Yeah. At the request of the learned counsel for the petitioner, matters then adjourned to be listed after 6 weeks.
Complaint.
It is Lordship, I beg to mention item number 52. Lordship, I am appearing on behalf of SD Roy, who is the engaged counsel for respondent number 9, 10, and 11. And this, your lordship, respondent number 9 had expired. So we need to be substituted. And the engaged counsel is not present, your lordship. He out of station for some.
Who died?
SD Roy.
Who died? Respond number 9.
Respondent number 9.
So the petitioner has to take steps.
Yes, yes.
You are the petitioner.
No, I'm the respondent. I'm
So
just.
if you say now, how will the petitioner counsel know? Let the matter be there. Then you say. Then only we can pass an order. He has died. So the petitioner has to take steps then.
Okay.
My lord, I pray on behalf of Mr. P.K. Roy Chaudhary, my lord. He's one of his juniors mother's expired. Now P.K. Roy Chaudhary is in, my lord.
Item.
Item 45, 46 and 61. Can it be adjourned for today?
And 61. Request of the request of the learned counsel for the petitioner, matters can be adjourned to be listed after 6 weeks.
Lordship, with the consent of the petitioner, I beg to mention item number 44, Lordship. Lordship, here the joint secretary had a heart attack, Lordship. We could not contact Lordship. After vacation,
So what do you want?
44. After vacation.
Huh? After
After the
the counsel appearing on behalf of the petitioner, matters in judgment will be listed after 6 weeks.
KAC, Lord, KAC. I'm appearing for Karbi Anglong Autonomous Council.
The Karbi Anglong? Okay. For a respondent, AAC, matters in judgment will be listed after 6 weeks.
Web results. Yesterday I made a request request in regard to item number 31, 32 for adjournment. But they have not responded. I have not agree with
31,
request.
32.
31 and 32. And 31, they've responded said file IA for vacating of interim order. And I am for the writ petition.
Then
That matter, today we have some difficulties, Lord. The matter will come after vacation.
other side,
State is there. Lord.
Yesterday they asked for function, but they have.
We made a request, but they have not agreed with my request.
state is agreeable.
They have, yesterday they asked Mr. Dutt.
I'm asking you, is the state agreeable? You have objection? Okay. Imagine.
So let's see, yesterday, we have filed an affidavit in item number 69, today's list, let's see,
Item,
69.
what do you want?
69.
Yes. You want an adjournment?
No, affidavit may be called for. Yesterday, we have.
Affidavit.
May it please your lordship, I beg to mention item number 50, lordship, 50. Matter is infectious, lordship.
Success.
Yes, lordship.
What's your name?
J Ghosh.
Huh?
J Ghosh, lordship.
J. Ghosh.
J.
J. Ghosh, the learned counsel appearing on behalf of the petitioner submits that the petition has become infructuous and as such the petitioner would not like to further proceed with the petition. Accordingly, the petition stands closed as it had become infructuous. Interim orders, if any, stands vacated.
Obliged, lordship.
Please, your lordship. Lordship, I beg to mention item number 26. Yesterday, we have filed the affidavit in opposition. There may be called.
You want to do the matter? You are calling for some document.
Filed affidavit in opposition.
Okay. You want to bring on record that.
So with your lordship's kind indulgence, I'd like to mention item 61 supplementary list. Matter has come up for admission today, where for the Silchar Municipal Board. But we could not file our affidavit yet. So, Lord, I am told the petition,
61 has been adjourned after 6 weeks.
he informed.
Mr. P.K. Chaudhary has difficulties.
Obliged.
What are no steps? Item 1.
Record reveals that the petitioner have not taken steps in spite of various opportunities, in spite of a direction being given. Additionally, the petitioner is not. Since the petitioner have lost interest in the instant proceedings for which the must from non-prosecution.
Item 2, part heard. For admission.
Yes, what is happening?
We have filed our last affidavit on 23rd of November.
That is okay, but what we are doing? Are you purchasing or not?
Being a public issue, my lord, and run by public, run by the public, and we are not allowed to enter any kind of private negotiation with the private party, man. So we would like to speak on our affidavit, the circular rate that has been quoted at 7,50,000 for 1 katta 10 lakhs, my lord. They have stick on to that.
It's the circular rate. When?
Page 70.
Page?
73. It has been flag marked as app.
Is of 2024.
Yes, my lord, latest. One bigger rate has been quoted as 25 lakhs and the price of one cutter 10 lecture is 7,50,000.
Then?
Before that, I'd like to point out that in the year 2020, the government has written a letter to the FCI stating that you take through direct purchase and at that period, the land price was only 1 lakh or below 1 lakh. But within this 4 year span of 4 years, it has increased by sevenfold, my lord. So the petitioner will not be prejudiced. 2.5.
Why will you purchase it? It will go as per the acquisition cost. This will go to twice the value, and along with that, this is outside the area. Where is this? Outside the
It has
rural
been outside
area?
Rural area.
The rural area. So into
Total
multiply by
fixed
2. So it will be 7,50,000 into 100% solatium will be 15 lakhs. 15 lakhs into 2, 30 lakhs. 30 lakhs is the amount for acquisition expenses.
Yes, that's.
You have to agree or vacate.
That land has also not been demarcated, my lord.
It has been demarcated. You vacate then. You are not willing to do it, you vacate.
Our hands are tied.
And you
Let them
vacate.
vacate it.
Yes, the state, we direct you to demarcate this land and show the portion which is in excess and thereupon hand over the possession to him. Heard Mr. K. Bhattacharjee, the learned counsel appearing on behalf of the petitioner. Mr. B.K. Singh appears on behalf of the FPI and Sami appears on behalf of the district administration. The petitioner herein has approached this court taking a writ in the nature of mandamus for settling the claim of the petitioner by paying adequate compensation in respect to a land at measuring 1 kata 17 lectures covered by dag number 1693 of patta number 331 in village Sangsari under Sila Senduri Ghopa Moza of Uttar Guwahati Revenue Circle in the district of Kamrup, Assam. From the materials on record, it is seen that the FCI, that is the respondent number 4 and 5, that an acquisition proceedings were initiated in the year 2015. Whereby land at measuring 202 bighas, 0 kata, 8.5 lectures was acquired and handed over to the Food Corporation of India. It is the case of the petitioner that the land of the petitioner measuring 2 kata 0 lesser covered by dag number 1693 of patta number 331 was also included in the area. However, it is the specific case of the petitioner that the remaining land of 1 kata 17 lectures covered by dag number 1693 of patta number 331 was not acquired and there was no compensation so paid. It is under such circumstances the petitioner had approached the respondent authorities time and again, including the FCI, for payment of adequate compensation as per law. However, for I approached the court alleging violation of his rights under Article 300A of the Constitution. Pursuant to issuance of notice, it is seen that various pleadings have been filed. From the various pleadings, it is clear that a plot of land of 1 Katha 10 lechas covered by DAG number 1693 or Patta number 331 belonging to the petitioner is in possession of the respondent numbers 4 and 5. The various orders which have been passed by this court categorically shows that the said land of 1 Katha 10 lecha was taken away by the district administration and handed over to the CI without following in violation to the mandate of Article 300A of the Constitution. It is also seen from the various orders being passed by this court from time to time that a due opportunity was given to the FCI either for going for outright purchase or getting the land acquired as per the mandate of law. It is further seen from an affidavit filed on 25th of November 2014-24 that the respondent FCI wants to purchase the land of the petitioner at the price of rupees 7,50,000 in terms with the valuation so reported by the communication dated 19/9/2024 to the respondent number 4 and 5 by the Additional District Commissioner Kamrup Amingao. Mr. K. Bhattacharjee, appearing on behalf of the petitioner, however, submitted that the value of the land is far more. He further submitted that either the petitioner, respondent number 4 and 5, has to acquire the land as per the provisions of the right to fair compensation, for short the Act of 2013, or has to go for an outright purchase at the rate which is mutually agreeable between the petitioner and the respondent number 4 and 5. The learned counsel for the petitioner further submitted that if the acquisition is carried out in respect to the land, taking into account the provisions of section 26 to 30, the petitioner would be entitled to an amount far more than rupees 7,50,000, in as much as the amount, if 7,50,000, in as much as the provisions of section 26 to 30 categorically shows that such acquisition, if carried out, would require payment of 100% solatium, and also in terms with section 26(2) of the Act of 2013, a further multiplication factor of 2 has to be applied as per the mandate or as per the notification issued by the state government. On the other hand, Mr. B.K. Singh, the learned counsel appearing on behalf of the FCI, had categorically stated that the FCI is only willing to purchase at the rate at rupees 7,50,000. So taking into account the above, it is therefore seen that the FCI respondent number 4 and 5 are not agreeable to purchase at the rate mutually agreed between the petitioner as well as the respondent number 4 and 5, nor is agreeable to make payment of compensation in terms with section, in terms with the provisions of the Act of 2013, if the state is to acquire the land. Under such circumstances, the fact that the petitioner, the respondents are in possession of, respondent number 4 and 5 are in possession of 1 kata 10 lechas of land at measuring 1 kata covered by dark number so and so. The retention of the such land by a state authority, by the respondent number 4, which is a state within the meaning of Article 12 of the Constitution, amounts to an infraction to Article 300A of the Constitution. This court, therefore, disposes of the incident with petition with the following observations and directions. Number 1, the Deputy Commissioner, Aminga, Kamrup Rural, Aminga, is directed to forthwith within 15 days from the date of the notice date of the certified copy of the instant order being served upon him, shall demarcate the land at measuring 1 kata 10 lecha, which is inside the premises of the dark number so and so, patta number so and so, village so and so, so and so, and hand over the possession of the said land to the petitioner. Number 2, the district commission, the district commissioner, Kamrup Petro, Kamrup Rural, is further directed either by himself or through his delegated authority or upon delegation to assess the requisition amount, the rental amount for the period from the date the land was handed over, the land in question, that is so and so, was handed over to the respondent number 4. And upon such determination so made, the same be sent to the respondent number 4 and 5 for due payment. The respondent number 4 and 5 shall, upon receipt of the same determination, shall make the due payment to the petitioner. With the above observations and directions, the petition stands disposed.
Unless your lordship.
Okay, 4 to 6.
Your lordship has directed me to get the instructions, lordship. I have received that instruction.
Yes, you are there. Good.
May I place it?
Who gave the possession to Biren Boy?
In paragraph two, Lordship of that.
Only read Annexure B. Have the Annexure B.
Next 42
The last
Annexure.
one. Annexure B.
This 23/9/2021 letter, Lordship.
No, this refers to 26/8/1962. Last in ASO
54/19.
So you gave the petitioner's father possession in the grazing reserve.
From the report, it is reflected like that, Lordship, at that time.
So now what has happened to 704? 704 now is what?
704. 704 is 1688.
Now you have removed the petitioner from where?
This 1088.
1688.
Sorry, 1688. As because he was in occupation of that government land, instead of that 730, 763 new. 17, if your losses comes to the next page, that serial number 4, that they were under the position covered under government doc number 704 old 1688 new instead of 730 old 1760 new.
But you allowed them to remain in 704.
Yes,
As
that
per
is
number
the,
2.
that is the grazing land.
So 704 was a grazing land.
From the report, Lordship, it reflects like that.
But you struck up their name in 1960.
Lordship.
Kindly come to number 2.
Yes,
As per
Lordship.
the draft sheeter record, land measuring 5 bighas 2 katha 7 lacha, covered under dark number 771574730, had been made patta KP patta number 135 on payment of premium of so and so. And as per the order in case number so and so dated Iman in favor of Khansur Ali and Iman, and the possession of Sriya was removed from dark number 771574 and 730. as per the ASO order. How? There was some application file.
Yes, Lordship, from that, it is reflected like that, Lordship, and some premium was also made for making it a patta
That
land.
was given. It's okay.
Accordingly,
So their patta was given to somebody else.
Lordship.
So patta was given to those persons. But he claimed to be a riot, isn't it?
Lordship.
Who came to a riot under those persons?
Yes,
It-
yes, Lord. That's
That is
Cosmo
your
Radia.
case.
Yes, I am a right.
You are a riot. Your father was a riot under those these persons, no?
135 patta.
Mansur Ali and Sukhana Sheikh.
Yes.
So then how did you remove the petitioner's name, the petitioner's father's name? Kindly show him Annexure B.
Lord.
Mr. Monto, we take up the matter after vacation. You have a look at these documents. You have a look at these documents which are here, which have been placed before.
Yes, yes. Well, there.
Because these documents may not be in a position to file it properly because these are original documents. So it's a huge.
We'll have to see it here.
I will show it to him. And the map also shows what appears from here is that your name, your land is there. Means it was there at dark number 730. This is what it was being shown that you were in possession of this land 20 years.
Original.
Your land, you were in possession of the land for 20 years at that point of time. So it has been shown in 730. Now the question therefore is, they say that we have vacated, only taken over the possession or evicted from 704, which corresponds to 1688. They say. We have not touched on 704, 730,
70.
which corresponds to 1763. This is their case. But there is one aspect. In 704 also, your name appears in the CITA. That is why I'm asking you to look into it. Here there are two copies. It's a big copy. Have a look at it. We'll have it after vacation.
Yes.
Mr. H. Sharma has placed certain documents along with an instruction pursuant to the orders passed by this court. First, this court, before further dealing with the matter, would like Mr. K.K. Mohanto, the senior counsel appearing on behalf of the petitioner, to have a look at those documents which have been placed in original. This court have returned the set of documents to Mr. H. Sharma and further request Mr. H. Sharma to permit Mr. So-and-so, the counsel assisting Mr. K.K. Mohanto, peruse the documents to list this matter again on 21/2025 for further hearing. On the next date also, Mr. H. Sharma shall produce these documents. Mr. Sharma, you again produce those documents on.
Apply.
7.
Yes,
No affidavit. No affidavit as yet in that.
page GMC. What happened to sixth and seventh law?
Started to break it. You started to break it.
You're being,
We have started demolition.
why you have filed your affidavit?
Affidavit not filed, also the instruction was issued. Detailed instruction.
So what remains? They're demolishing.
Bring in private affidavit.
Ah. What remains now? Your basic question was that they were not taking any action. Now action has been taken, nothing remains. Mr. Naik, we have this matter on 2024. On which date? Because he has said 3 days now. They have informed on 13/12,
But I have seen photographs also, it has been demolished.
demolished.
Why not only one part, the back part, because the neighbors are there. What we have done, we have made a bamboo thing in covering so that the debris doesn't. That part remains, other everything.
So just put it on affidavit that correct, the learned counsel, standing counsel for the GMC has placed before this court at dated 16/12/2024, associate planner of the GMC, who's taking into account that the respondent number, phone number? Five, has already started demolition of the unauthorized construction of the sixth and the seventh floor, which may require another, which is likely to be completed soon, as submitted by Mr. Jed Mukid, the counsel appearing on behalf of respondent number 5, this on 20/12/2024, on which date an affidavit be filed bringing on that the documents dates before. So, just short affidavit.
2012.
2012. Short affidavit that bring these documents and the photographs. And then we close this, nothing more.
Item 8,
Yes. What do you mean? That's it given, go there. The so and so, the learned counsel appearing on behalf of the petitioners, that taking into account that the charge it has been already stated. He would not like to further press the instant petition. Learned counsel, however, submits that the petitioner, the rights of the petitioner to appeal such other remedies before the criminal courts should be kept open. Taking into account the above, the instant petition stands closed. However, the petitioner would be able to take appropriate steps before the court wherein the charge sheet has been submitted.
item 9 and 10,
Private respondent number 7.
Your name, I will give it in. Yes, what is it?
Just a few moments ago, I can start with two copies of the affidavits filed by the APDCL. But they have filed it today. So
So and so the learned counsel appearing on behalf of the petitioner submits that the APDCL has filed 2 affidavits today, which he would like to,
in both the cases,
in separate order, no? Separate order in which Mr. So and so the learned counsel appearing on behalf of the petitioner has submitted that the APDCL has filed. You submit today. and has served a copy upon him that he would like to go through the same and
This come after 4 weeks. After 4 weeks. Naman.
Seven, you give your name in that slip. Otherwise. What is this?
This is a matter where a petition was filed with the learned DC 2016 that had not been heard. So we are just seeking that the DC.
What petition you have filed?
These are
Yes. Why you not disposing of?
dispose of plots. Dispose of plots.
Dispose of miscase?
Plots. We are not aware of the disposal.
Fantastic. We put it as X, you take a certificate copy.
Copy may be given. The fragment please copy.
They heard Mr. Dida, the learned counsel, appear. Sir? Eight.
I'm appearing for respondent number 15 to 20. 15 to 20.
The instant petition was filed seeking abandonment, directing the respondent authorities, more particularly the respondent number 2 of the miscase number 190 of 2015-16 in accordance with the time-bound manner. Me appearing on behalf of the respondent numbers, appearing on behalf of the district administration submits that the said petition have been duly disposed of by an order dated 17/10/2023. And the said order I was placed before this court during the hearing. The said documents are kept on record and marked with the letter X. That his client have not received a copy of the order.
Because your Honor, hearing also was not one order, Your Honor.
You wanted a disposal, matter is over.
I don't,
If you have anything, you have to challenge this order for whatever reason.
I want to just confirm that this is in fact my petition that has been disposed.
You
Because-
say Miss case number so and so has been disposed of in the office of the.
It should be case 190 because the hearing took place on 3/8/2022. As per one order, I'll show Your Honor, 25/7/2022. That was the last hearing that took place. No notice has been given after that. So how has it been disposed?
What is your case for, Miss case for?
It's for cancellation of mutations
Of,
of a series of flats. So there were basically what had happened was there's a plot of land. It was given to a builder. The builder misused certain
cancel the mutation alleged to have been done in illegal manner on the ground that the power of attorney so and so became invalid
That's
after
correct.
so and so. Isn't that the
That's
case?
correct. But one order was passed by the circle officer.
No. Kept that for the X. So taking into account that the order has been already passed. Case number 190 of 2015-16. Nothing further survives in the petition. So and so. And Goswami helpers provide a copy of this order to us during the course of it.
Obliged.
Item 12.
Maybe. But
I am extremely sorry, yes, in another court, my lord. Now, in this case, my lord, we have seen from the affidavit in opposition, my lord, my claim has been rejected. Now we have to challenge that, my lord, rejection order, my lord, passed by the, my lord, strictly service authority,
This one, 2712.
my lord.
Okay, file an additional affidavit. These matters don't go for all these things.
Right.
File an additional affidavit. Although I would have otherwise in other matters I would have allowed. I would have insisted. But here it's on the question of the delay, na?
My lord,
7, section 7.
plus 7,
7. Wherein it says you have to file within 1 year of the date of the crime.
exactly.
When did you do it?
It was after, my lord, the statutory period. It was filed on, my lord, 11/11/2020.
And when did the crime happen?
And, my lord, incident occurred, my lord, on
Who is paying for AL? You file an additional affidavit.
Right.
Mr. M.A. Mondos, he would like to file an additional affidavit in the matter and permits that he requests for 4 weeks' time for the purpose of filing appropriate pleadings, filing an additional affidavit as well as reply to the affidavit in opposition. When did they fix the other matter? 6 weeks.
I have no, my
That
lord,
day matter, that is also same, na?
yes,
Where I said that you have not taken steps. You were there.
yes, yes, yes.
You were there. So in that matter, did they fix a date? No.
Road test is not given after 3 weeks, like that.
Matter. Do you have the number?
I'll give the number.
This is matter along with so and so. On 9th of January. Because we need to make this thing correct. Because you see, 357A may say so. But if you are for only from the crime and tomorrow something else happen, means well, immediately he has to file the application, that is very noble. But would they take away your right to receive it? If there is a crime, can there be a limitation on that aspect? Okay, so we do one thing, because they cannot do it, so we may have to pass appropriate orders for this. State. Yes. Here what has happened, you have a Assam victims compensation scheme. Clause 7. Victims compensation scheme is made under section 357A of the Criminal Procedure Code. And now there has been a lot of evaluation that these benefits should be given. Now, what you have done is, you in clause 7, you have incorporated a term that within 1 year, one has to file an application for receipt. He said that take away his rights, which he is otherwise statutorily entitled under 357A. This question we will hear on 29 January. Number. As Guru appeared. You questions 27, clause 7, on the basis there.
Yes, and that has been challenged in the earlier writ petition, Lordship has referred.
Maybe
Correct.
the number.
My lord, I will give the number.
And have you
No, I
taken
am
the steps
30.
or not?
My lord,
In that matter,
in that matter, that has been challenged.
have you taken steps or not?
Yes, steps taken. My lord, I am extremely sorry. In respect of item number 1, I have missed, my lord, because of traffic jam, all these, my lord.
I dismiss for default.
Yes,
Why? You have not taken steps.
I have taken
3, 4,
steps,
5.
my lord. I have taken steps, of course, by late. We have taken steps.
Taken steps?
Yes,
When?
yesterday, my lord.
Item number 1 to Mr. M.A. Mondo, the council appeal. the same and do the new.
Deep law plus.
But equal to beside you. Yes. Kundu. Oh, no, no. Two. Yes, Mr. M.
13.
You filed the amended petition.
He lost, yes.
What is this amended petition for?
Was filed on worship.
Government, you have filed affidavit.
Not filed on.
What are you asking for?
In this case, my lord, either to leave the land or pay compensation.
Directing the respondents to vacate the land, petitioner's land under Dak for 417. What is that land belongs to whom?
One of the petitioners lost, joint owner lost.
Huh?
Joint owner lost.
Joint owner of what?
Now petitioners are the joint owner of pata holders. Two
Two
brothers.
person are joint owners of 417 bighas of land.
My lord, 2 bighas, 3 bighas, 2 quarters, 15 less of lost.
How much is the land?
My lord, Zawamandi is at place 11 lordship.
First of all, we shall not accept your petition. How are you filing the amended petition without your enclosure? What is this type of a petition you file? Tell me. Means we are to see this petition and then look for the earlier petition for the enclosures.
It was given probably by mistake. to the lordship.
Mistake,
My lord, I'll provide.
it,
I'll submit, my lord.
the action.
My lord, I'll submit, annex the money.
You have not filed it.
My lord, the
You have not filed the amended petition within the
amended
time and as such, why shouldn't we dismiss your petition at all? The amendment.
amended writ petition lordship.
What is this type of things you are doing?
I'm sorry, lordship, I may be allowed to file. My lord. Without my lord,
This court has
annexer is not.
perused the amended writ petition file, but it surprises this court to take note of that the amended writ petition does not include the enclosures. Under such circumstances, the said amended writ petition so filed cannot be said to be a properly filed. The so-and-so MH
Within a day, lordship.
appearing on behalf of the petitioners, a 6 weeks time may be granted to file the amended writ petition. Just accordingly. Filed after 6 weeks.
Lordship.
Item 14.
Oblige.
Hey, what is this? You want money?
Yes, my lord, but.
You're not paying.
Lordship, this is a FMP matter, Lordship.
This petition starts and finishes. Post title is bigger than the petition. Huh? What type of petition is this? The post title is bigger than the petition. Tell me. Why you have not enclosed the tender? Copy of the 2 work orders. Then, did you submit the bills? How do we know? Is a writ petition, are writ petitions not to be decided on affidavit as well as the documents? Why don't you go to the trial court? You will learn more. Go to the trial court.
Temporary judgment, my lord.
You say that these are disputed questions of facts, you go there. Because you have not enclosed any document.
Temporary
we?
judgment is there, my lord.
Huh?
Full bench judgment, temporary judgment, my lord.
What?
Covered this case, my lord. Temporary judgment, my lord. Full bench judgment, my lord. is there.
Temporarily, you would not apply to WI, this water resource. That is for PWD.
Similar, my lord.
Similar may be similar. Isn't it a concessional judgment? Temporarily. Temporarily is a concessional judgment given by the PWD department, not by the government of Assam. How is it applicable?
Similar nature, my
There
lord.
are no similar matters out there. Do you accept them temporarily? No. Matter over limitation barred. Barred, no? 3 years,
Yes, Lord.
card. Card. So Mr. Sharma argue that when you cannot do in the normal process, extraordinary jurisdiction under Article 226 should not be initiated. He cannot file a suit today. So under such circumstances, why should this court exercise this? Where there is no even any explanation as regards the delay or latches. Nothing.
And moreover, Lordship, they have not annexed the liability statement.
No. We dismiss this on the ground of the doctrine on latches. Go to the division bench. Not a single word why this has happened. We are more interested in getting an order from similar order.
Communication was going on.
Similar order, this is public works. How can you enforce upon them? Public works department has lots of money. They don't have.
This was also related to public, my lord, the works.
What?
The works related to public, my lord,
What public? No public.
government department, my PWD also.
Are you doing it for free? You want money, so you have done it. But why were you sleeping? You were entitled to the money in the year
The
2015, copy of the work orders. And when did you complete? Work order completion date was what?
Work order issued by the executive engineer, my lord.
Where is the completion certificate? Completion certificate is where?
And two works order are there, my lord.
Where is the completion certificate?
The department, my lord.
And when you filed the writ petition, it was 44 lakhs. Now it is 24 lakhs.
The
There is not a document to show that there is a completion certificate also. Then why should we? We should dismiss it right away. This type of cannot be encouraged.
my lord,
No, we dismiss it. You got the money last time. When did you get the money?
I have to take instruction, my lord.
You have no instruction of the. We should dismiss it right away.
On the next date, my lord.
No. Take
I
it
will file
before the
affidavit, my lord,
vacations.
additional affidavit, my lord, in this case, my lord.
Additional. Once you have already filed your additional affidavit also. How many additional affidavits you are going to file? There is no document which shows that there is a conclusion. You have completed. No document that you have raised bills. Then only we can ask them to verify. You know, therefore I was saying, your cause title is bigger than the petition.
I will file on the.
Okay, Mr. What is your name?
DK Jain.
Mr. DK Jain, the learned counsel for the petitioner, seeks for an accommodation. This is the matter of the 6 weeks. Take up that ground. File an affidavit. Take up that ground. Yes. What is this? Epidicial. What have you done?
My lord, the electrical inspector has submitted the report, my lord.
Huh?
Yes, my lord. The government has,
What does the electrical accident say?
yes, my lord. The report is started from running base 30, my lord, 31, and the operative part, my lord, base 33.
Yes, epidicial.
Lordship, we are not preferring affidavit.
Okay, you have a similar order?
My lord, on record, my lord, in the earlier occasion, I have given my lord, lordship order in the file. This, my lord.
Order?
Yes, my lord.
Very good. Too long an order.
Yes, my lord. Last paragraph, my lord, 23 and 24 is the operative part, my lord, paragraph 23 and 24.
Wait, what are you asking for? When did the incident happen?
Incident happened, my lord, in the
2019.
2019. 19, my lord.
2019. Now you are asking for interest also?
Yes, my lord, as per the notification issued by the government, my lord, this is also on file, my lord.
What?
After 120 days, the interest. There is a notification also. That second page, my lord. All claims shall be finally settled within a period of 120 days from the date of occurrence of the electrical accident. Delay in payment of compensation shall result in an additional interest of 12% per annum. Second page, my lord.
Occurrence was prior to the, occurrence was prior to the, office memo.
Which office memorandum?
It's 7/11/2019.
When did that regulation happen?
Regulation
7/11/2019.
No, that AREC regulation, when did it happen? When did it come?
2019, my lord.
2019, Lordship, 5/8/2019.
In the notification acceptment.
19.
5/8/2019.
This incident happened
It was on 18/7/2019.
18/7.
18/7.
Yes.
So
Covered.
heard Mr. M. Hussain, the learned commission appearing on behalf. J.K. Rusami appears on behalf of the respondent numbers 2, 3, 4, 5, 6. As Bulwa appears on behalf of the respondent. Petitioner is approached this court by filing petition claiming compensation count of debt of who is he?
Husband died, my lord.
On account of the death of the husband of a petitioner due to the negligence of the respondent numbers 2 to 6. Details on record reveals that on 18/7/2019 at about 1 p.m., the husband of the petitioner went for catching fish in Kurmibil of Gwalpara district, and suddenly the electric live wire was torn and fell on the body of the husband of the petitioner. Resultantly, the husband of the petitioner died on spot. The brother of the petitioner, the brother-in-law of the petitioner thereupon filed an FIR before the Gwalpara police station, which was registered as Gwalpara PS UD case number 21/2019. The postmortem of the husband of the petitioner was carried out on 18/7/2019 itself, and it was opined that the death was due to cardiac shock on account of due to what is this?
Cardiac due to electric burns.
Due to cardiac arrest. You have written is cardiac due to cardiac arrest due to electric burns, which were anti-mortem in nature. The report further reveals that the petitioner submitted, why should we give you? You filed interest only on 2/1/2023. Why did you apply so late?
My lord. Initially,
Initially, there is nothing. Therefore, on 2/1/2023, the petitioner approached, submitted a representation seeking compensation of rupees 20 lakhs on account of the death of her husband due to electrocution. The said representation having not been considered, the instant petition was filed on 8/5/2023. 18/5/2023. Next. The record reveals that pursuant to issuance of notice that this court by an order dated 24/5/2023 issued notice. The APDCL authorities have not filed any affidavit in opposition. However, the electrical accident report, inquiry report was filed on behalf of the respondent number 6, wherein electrical accident report dated 3/7/2023 was filed by the respondent number 6, wherein it was opined that the accident occurred due to the negligence on the part of the APDCL authorities due to contravention of regulation 12(1), 13(1), 13(2), 16(1), and 35 of the Central Electricity Authority measures relating to safety and electric supply regulation 2010. This court have duly heard the learned counsels appearing on behalf of the parties and have behalf of the parties. Mr. J.K. Goswami, the learned counsel appearing on behalf of the APDCL submits that though the respondent APDCL have not filed an affidavit in opposition, the petitioner herein can at best be entitled to the amount of rupees 4 lakhs as per the AERC compensation to victims of electrical accident regulation 2019. He submits that that any other compensation, if any, can only be decided by the civil court in terms with clause or section regulation 9 of the said regulations. This court have also duly taken note of regulation 5 of the regulations as well as schedule A. Schedule A of the regulation. Schedule A, wherein it is seen that the amount of compensation to which the petitioner would be entitled to in the present case would be rupees 4 lakhs. Taking into account the above, this court is of the opinion that taking a would be entitled This court further duly takes note of the submission of Mr. M. Hussain to the effect that the petitioner is also entitled to interest. And in that regard, have placed before this court an office memorandum dated 7/11/2019. The learned counsel for the petitioner therefore submitted that the petitioner would be entitled to the interest if the claims are not settled within a period of 120 days from the date of occurrence of the electrical accident. So this court have duly taken note of that the incident, there's no mention anywhere that the electrical incident was duly reported to the APDCL authorities. It is first seen, it is from the perusal of the petition, it is first seen that it was only on 2/1/2023 that the chairman of the APDCL was duly informed about the said incident, claiming compensation and thereby submitted a representation. Under such circumstances, in the opinion of this court, that the petitioner would be only entitled to the interest after 120 days from the date of after 120 days from 1/1/2023. When was it? 2/1/2023. At the rate of 12% per annum on the amount due from the due date of the payment. Taking into account the above, the instant petition therefore stands disposed of with the following observations and directions. The petitioner herein would be entitled to the amount of ₹4 lakhs in terms with Schedule A, na? Schedule A? Schedule A? In terms with Schedule A, read with Regulation 5 of the regulations, regulation the petitioner further would be entitled to interest with effect from on a post 120 days after, no, post 120 days from 2/1/2023 till the date of actual payment at the rate of 12% on the amount above mentioned. The respondent authorities, more particularly the respondent number 2 to 5, are directed to make payment of the said amount along with interest as above mentioned, above directed within 30 days from the date a certified copy within 30 days. I say you inform them, because why, if they give it late, then interest will accrue within 30 days from the date of the instant judgment. Now, within 30 days, instant judgment, provided the petitioner furnishes the bank details to whom? To the respondent number 3. Respondent number 3 or this one, 5. 5 will be better.
Lordship, it may be on 3, Lordship.
On respondent number 3. Wherein the amount could be transferred along with the next of the kin certificate. Number 4. So the above adjudication and the directions so given shall not preclude the right of the petitioner to take such other actions if permissible under law in terms with Regulation 9 of the regulations.
My lord may be pleased to find the impugned order is at page 39, annexure 8, my lord.
but instructions are awaited, but still, page 25, my lordship, see, the initial order, whereby there was a recommendation for settlement. I don't see any settlement order in their favor, my lord, in the petition.
Yes, Mr. Bhuyan.
My lord, if my respected friend has drawn my lordship's attention to page 25, my lord. It in the second paragraph, my lord, it says that the possession of the land may be handed over to the, my lord, person concerned, my lord, after the payment of the premium. Lord, accordingly, I have paid the premium in the very next page. And my lord, thereafter, possession has also been handed over to me, my lord, my father, my lord. And till date, my lord, it is a long back, my lord, in the year 2006. And the government was sitting silent without doing the rest of the formalities as per this letter, my lord. They, obviously, my lord, they are required to issue the settlement order because it is a land advisory committee's, my lord, approval was also there. Now, my lord, after this, my lord, we have, my lord, this letter had been issued at page 25 by the Deputy Commissioner. My lord, may kindly have a look at page 27, my lord. This is a, my lord, letter issued by the Deputy Commissioner to the Settlement Officer, my lord, at page 27, Annex 3. The marginally noted letter, I must respectfully beg to government.
No,
recommended for-
everything.
My lord, my lord.
The settlement order was issued. There's no quarrel that there was no settlement
No,
order
no, my lord.
issued. Settlement order was issued, that can be seen from Annexure 1 to the affidavit filed by them.
My lord.
Inviting a reference to the letter on the subject, I'm directed to inform the governor of Assam is pleased to cancel the settlement order issued by government letter number Iman dated Iman in favor of so and so.
Whether, my lord, such settlement can be cancelled in this manner, my lord. That is an issue, my lord, because it was issued long back in the year 2000, my lord, 6, 3.
And that too without nothing,
Any, giving the opportunity of hearing, my lord.
no opportunity.
That I need to get the instruction, whether it was any opportunity was given or not.
My lord, we have not received any notice as such, my lord. Your contention, my lord, is that this is a very, my lord, restricted area under, it is just near the Dispur Law College, my lord. My lord, lordship may have seen the area, my lord. Just near the Dispur Law College and other establishment and other peoples are also there. Now, my lord, they are also issued the settlement order in the same manner, although they have denied here in this impugn order, my lord. But those latter, we could not get the access of the same because the peoples are, my lord, afraid of that our settlement may also be got cancelled, my lord.
But I don't understand
My lord.
why, regarding non-completion of the settlement process, you filed a writ petition in 2017.
My lord.
Meaning,
Because, yes,
meaning thereby what?
because, my lord, what has happened, my lord, the settlement order which they have said in Annexure 1, my lord, was, I have also inquired into with the petitioner, my lord, that because it is in the possession of the petitioner's father, my lord, ought to have. But there are some dispute with the father and son, my lord. That's why all the records were not available with the present batch of petitioners, my lord.
Where's
And
the father?
secondly, my lord,
Where's the father?
my lord,
Where's the father?
father not expert. Father is there, but there is a communication gap with them, my lord, because after the expiry of the, my lord, first,
Why are you filing?
my lord, because, my lord,
If the father is alive, who are you?
We are the legal heirs, my lord.
How? How can you be a legal heir?
Because, my lord, we are the sons residing
So?
therein, my lord,
So,
along with my father.
you have no locus.
So, my lord,
Now, if the father does not come, who are you?
my lord, as we are residing therein, my lord, we have a rights to.
No right. They are not going for eviction.
No, my lord.
They are for cancellation of a patta which have been issued in favor of
Settlement
the
order.
father.
Right.
The father is alive. The father doesn't want to challenge. Who are you?
But the
No
legal-
locus standi.
But then may I take a, my lord, permission from my lordships to obtain an instruction regarding the present status? My
No, no.
whether,
Petition otherwise is bad. Have anything, your father could have filed it. You
my
could
lord,
have filed it.
that aspect is there, my lord. No, Manpur JSN and I don't know.
The instant petition has
My
been
lord,
filed back.
My lord, may I pray, my lord, that whether the father is in alive or not, that instruction.
Yes, in the petition son of.
My lord, son of, that is correct. Lord. Then, my lord, we may be allowed to withdraw the petition, my lord, by an appropriate forum, they can come.
You do one thing.
My lord,
You withdraw the petition with the liberty to file it to your father.
my lord, my lord. That will be an appropriate time.
But Mr. A.R. Bhuya, the learned.
Yes, I know.
Mr.
Second marriage. Number one.
Petition. Instant petition held by the petitioners. I think the order dated 19/5/2020. Thereby challenging the, are you challenging both the orders?
My lord. No, my lord, only 19.5, my lord. Because that impugn, we do not have
You should
the,
have challenged this also.
that is correct, but that,
Challenging the orders dated 19/5/2023
Fine.
issued by the Joint Secretary to the Government of Assam, Government of Assam Revenue and Disaster Management Department, as well as the order dated 19/5/2023 passed by the Deputy Commissioner, Kamrup Metro, whereby the settlement so made in favor of the father of the petitioner was cancelled. From the materials on record, it appears that the father of the petitioner is very much alive. And not, and there is no materials on record to show that the father, after the settlement have been granted in favor of the petitioners, in favor of the, in his favor, have passed on the title in respect to the land to the petitioners. During the course of the hearing, Mr. A.R. Bhuya submits that the petitioners would be well advised to withdraw the instant petition and sale the impugned orders if the father of the petitioners wishes to do so.
Fine.
Taking into account the above, the instant petition stands closed on withdrawal. However, liberty is given to the father of the petitioners to assail the impugned orders, so assail in the to impugn the assailed orders, to assail the impugned orders, if so advised, in them orders, if any, stands.
oblige.
We have a case, Mr. Bhuya.
Fine. I can understand. Item 18. Oblige.
In this matter, my affidavit has been clearly filed and the compensation has been released to the person concerned. Your Lordship.
They pay the compensation
Yes, Your Lordship. Annexure A,
and appears on behalf of the petitioner on call.
respondent number 3, Your Lordship.
R.H. Chaudhary, the learned counsel appearing on behalf of the respondent number 3 submits that the petitioner have already been paid the compensation in terms with the Assam Victims Compensation Scheme 2000.
Well,
As such, nothing further remains in the which the writ petition stands closed.
obliged.
19.
Yes, please, Your Lordship. The petitioner already received the house rent.
Huh?
Petitioner has already received the house rent. Matter may
The counsel, Ms. Swenson, appearing on behalf of the respondent, petitioner submits that the petitioner have already received the amount for which the writ petition has been filed. Taking into account the above, the incident stands closed.
20.
What is this? It's so big. Tell me.
Regarding the pharmacy, my lord, cancellation of registration of pharmacy.
But
Then
the owner division bench has already decided this matter. Matter has become instructors, madam.
structures.
The division bench has already said that.
Whether
They have
the
been given the opportunity to prefer an appeal before the government. Against the cancellation of it.
And also directed them to furnish the courts.
you have been asked to file an appeal.
Yes.
Here you have come against the cancellation orders.
Yes, madam.
Huh?
Yes. Page number 330.
Which are the cancellation orders?
The next 106, page number 330.
So 6, 8,
330. 330.
2.
From the start.
How many persons?
They are already 22%.
106 to
127, madam.
6. Isn't it?
Yes.
Heard Mr. So-and-so, the learned counsel appearing on behalf of the Google appeal on behalf of the Pharmacy Council of India. It's a conflict of interest. As well as the health department of the government of Assam. Petitioners have herein have assailed with the various orders from annexure 106 to 127, whereby the registration of the petitioner as pharmacist have been cancelled and their names have been removed from the register. It has been submitted by the learned counsel appearing on behalf of the petitioner that similar matters have been dealt with recently by the division bench of this court in WA number 431 oblique 2023, whereby an order was passed on 24/11/2000, whereby permitting the said pharmacist whose names were removed from the register to file appeal before the state government in terms with section 36(3) of the Pharmacy Act 1948. He further submitted that if the learned division bench had also observed that till the cancellation, till the have you asked for the resolution?
Yes, ma'am.
He further submitted that the resolution of the executive committee and the confirmation by the state council have not yet been furnished to the petitioners. Is it? Where is that? Where is the prayer? Where? No prayer. No prayer.
We have paid for filing appeal.
No, nothing.
On that day, my lord, during the time when the appeal was heard, for my lord, non-granting the interim protection, the appeal was moved. They changed their prayer, they said that they will go for appeal instead of.
No, this order cannot be passed. Means once you have cancelled, remove them from the premises, how do you bring them there? You'll have far-reaching consequences. Not passing them. First. Permitted filing of appeal taken into taking into account the above. Taking into account the by the division bench dated 11/2000 WA number 431/2023, as well as the provision of section 36(3) of the Pharmacy Act of 1948. This court would not like to exercise the jurisdiction under Article 226 of the Constitution. The petitioners herein are given the liberty to file appeals within 30 days from the date of the instant order.
Date appeals are similar to petitioner. When they did not receive the interim of protection, they have approached the division bench.
Against this order? Against this case?
Yes, ma'am.
Yes, madam, in the present case.
The present case.
But they.
People went there,
Yes.
so nothing remains.
No, other, no, my lord, it's a limited, my lord, protection has been given. It's not that, my lord, they can continue with with the stay order. Within a time frame, they will, my
But-
lord, approach the authority and they will keep, my lord, till the date of receiving that particular resolution from the pharmacy
So
council.
these are the same petitioner.
Same petitioner.
Okay, Ibn Alagi.
Otherwise, my lord.
But Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, as well as so-and-so appearing on Ekilibo. The instant petition has been filed challenging the orders, the cancellation of, challenging the various orders by which, and from annexure 120. The question of what?
106.
106 to 126. 126, whereby the petitioners' names have been removed from the register of the Assam Pharmacy Council, as the petitioners have failed to submit any relevant documents justifying their qualifications to substantiate their eligibility to register as pharmacists in terms with section 31A small a or 31B small b or 31C small c or 31D of the Pharmacy Act 1948. It has been brought to the attention of this court that being agreed by non-granting of an interim order by this court, an appeal was prepared, being read appeal number 4 by the petitioners given an opportunity to prepare an appeal under section 36(3) of the Pharmacy Act 1948, and have also been given certain limited interim directions. Taking into account the above, learned counsel appearing on behalf of the petitioner submits that the petitioners are in the process of filing appeals. In that view of the matter, nothing further remains in the writ petition, for which the writ petition stands closed. So that is very difficult.
21.
But my lord, same issue. I pray for my lord this similar order, my lord, not the one passed in the writ appeal.
Huh?
Yes, my lord. Same my lord, cancellation of registration.
But they didn't go.
No, my lord, it has come up today. Lordship can dispose of, my lord. There is a limited protection given till the date of receiving that, my lord, resolution from the, my lord, pharmacy council. Lordship will see para 9. Para 9.
Has he asked for that? If you
Otherwise,
have
my
not
lord,
asked, why will I
they,
give? I am not so.
my lord. The only, my lord, prayer for quashing of the cancellation order.
And appears on behalf of the petitioner on call. Mr. B. Gogoi appears on behalf of the Pharmacy Council of India as well as the Health Department of the Government of Assam. The petitioner herein have said the removal of his registration from the register of the Assam Pharmacy Council.
So she will post it tomorrow or day after tomorrow. Then, my lord, because if they don't come to know about this order, they will not approach us. That's the difficulty. If unnecessarily they will get a protection. It will be day after tomorrow. If don't come, if they don't come, my lord, she will dismiss it for non-proceedings. There are 9 days, my lord, that within 10 days they will have to approach. Otherwise, my lord, the interim will be vacated.
Oh, I won't pick up this matter. My name is there in all. It's the matter before any other bench.
May I please, Your Lordship? My lord, the petitioner's late husband donated some plots of land for setting up of a school in the name of the petitioner's late father-in-law.
You have filed a reply.
Yes, my lord.
Petitioner has filed an affidavit in reply. However, the same is not in record. This matter, we have urgency. We have urgency. This is matter on 21/2025. The registration bring on the same affidavit.
Interim stay may continue.
Australia shall continue.
23.
Wait. There is the interim order. Oh, it is,
17
don't require that. This is already there. Number 4, it is 22 says that interim order earlier shall continue till the disposal.
Yes.
Good right. Yes, madam, what is this? Contractual bills.
This has been submitted, my lord.
Huh?
Demand of the memo, the amount contingency bill has been submitted, my lord. Due to non-available to the fund, my lord, the amount not be paid.
What do you want to do? Are you objecting, not objecting?
Not
What?
objecting, my lord. I am not objecting, but demand has been sent for bill, my lord. Demand proposal has been sent, my lord.
The SNA of the Learned Council appearing on behalf of the Irrigation Department submits that the petitioner's bills have been sent for processing, and as such, some time would be required. This matter again on 12th of February 2025 for an update.
24.
Same.
Huh?
Same. method. Biplab.
25.
Okay, please, Your Lordship. Lordship, matter may be passed over for the time being, my lord.
Right?
We have made the payment, my lord.
Yes, what has happened?
We have made the payment, my lord. Lordship, I can hand over the documents. There is nothing left, my lord. 13 lakhs. We have executed the documents, my lord.
Nothing remains.
Nothing remains.
You can do one thing, put your name out there, that's all. Put Mr. P.K. Munir's name. Is he around? In the vicinity of the High Court?
He's on lakes.
Yes. So he's inside the court premises. Mr. P.K. Munir, the learned counsel appearing on behalf of the Mr. A. Roy, the learned senior counsel. So and so represents the respondent number 3 and 4. Who appears for the respondent number 2. 1 and 2. Union also appears for the Union of India as well as for the administration. The petitioner herein has approached this court seeking a direction for release of the compensation amount in his favor to the tune of rupees 13,66,729, along with interest at the rate of 6% per annum since the time the compensation amount was due for payment. From the record, A. Roy, the learned senior counsel, submits that paid amount of rupees 13,66,729 had already been paid to the petitioner through bank transfer, and the same is evidence from the documents placed before this court during the course of the hearing. He further submitted that the petitioner has also executed an affidavit before the debate about his satisfaction with the amount that there is also an taking from consideration being given by the petitioner, taking into account the above documents so placed is kept on record, and found the above, nothing further remains in the instant petition for which the same stands closed.
26.
For the time being, Lordship, my senior is laying in court number 19.
Ooh.
Senior is laying in court number 19.
Okay, let him be in the legs. Is this, Mr. Corporation Department?
I filed the affidavit, ma'am. And record is also present, ma'am.
Did you file?
My lord, in fact, by today, my lord, I have brought it by way of requisition. I filed yesterday. My lord.
The respondent number, it has been seen that the respondent number 2 has filed an affidavit in your possession, which the counsel appearing on behalf of the petitioner submits that they have received a copy of the same and would like to go through the same. Accordingly, the writ petition stands adjourned 2025. Mr. Munir, we have closed it.
But we also pray for some increase.
What interest? No interest, because go there. We have
The act provides.
understood. You have gone, but you have satisfied with all these documents which you have say that I have satisfied with all these things. What remains? You have satisfied with the amount.
27.
Amount has been paid very late, my lord. The act says, my lord.
Understood, but why did you execute the documents expressing satisfaction? Why?
I could not understand, my lord.
You see, you have received 13,66,792, which was the amount you have claimed. Now that amount, whatever it is, you have received it.
Yes.
You have executed 2 documents. One is an undertaking agreement for another thing, and the other thing is a satisfaction. What remains?
Satisfaction. That I'm not aware, my lord.
Have a look at the documents. Otherwise, if you have any problem, we'll take it up at 2. Just have a look at the document.
I'm grateful.
Yes, what is this?
Lordship, item 26. May it please your Lordship.
Lordship, here the petitioner has been deprived of its legitimate right for not being able to ingress and egress the industries, Lordship, which is situated over a plot of land about 60 bighas, Lordship, covered under dark number 484 and 485, Lordship, which is situated at Napamoma, Sinamora under Gormur Moja. And Lordship, the case of the petitioner is that, Lordship, so the PWD Sinamara Road, Lordship, that beside that PWD Sinamara Road, one railway track is there, Lordship, and that is Jorhat
Have
Mariani.
they admitted your case in the affidavit in opposition?
Lordship, they have admitted our case, Lordship, in terms of our last order dated 22/5/2023, Lordship. They have admitted that they are supposed to be a level crossing, Lordship.
I'm saying in the affidavit filed on 23rd of October 2024, have they admitted your case?
Lordship.
Then why are you not filing a reply?
So,
Else
Lordship,
we are going by
there is
the,
urgency, Lordship. So, Lordship, hear me first, Lordship. I need a interim protection in this regard.
what
Lordship.
interim protection? You have not got your interim protection since long.
Yes, Lordship. But
Then
Lordship,
why should we give you?
there is a urgency in the case, Lordship, because that level crossing, Lordship, that was supposed to be closed by them, Lordship. And if it is closed, then Lordship, it would be hamper our Lordship industries, and day-to-day activities were hampered, Lordship. Around 700 to 800 workers were employed, Lordship.
What is happening? What is the problem?
Lordship, there are two gates, Lordship, unlevel crossings, unmanned level crossings. Now, out of two, Lordship, one level crossings was closed, Lordship, but one unmanned level crossing is still there, and we are using that crossing to ingress or egress, Lordship. Now, the railway, Lordship, have issued one notice. Then they are saying that they are going to close that crossing, Lordship. So, our contention is there
Yes,
is
yes,
a
why you are closing it? Why you are closing it? Where will these people go?
But there is,
You want
need
to
for
close it.
electrification is going on, that is electrification.
No, it's okay. Electrification is going on, do it. Go ahead with the electrification. Put signboards, whatever may be. But if you close them, where will they go? They will jump over. And then you have the another thing, that penalty. Then where will they go? How will they go if you will have an unmanned one? Means you have to have a gate or something to the effect. What to do?
Take them, my lord. We'll take a decision, my lord.
Decision, where is the notice, madam?
notice is, Lordship, I have during the pendency of this writ petition, Lordship, they have filed another notice that I have annexed in my additional affidavit, Lordship. They kindly see that affidavit.
The notice. Banning of unmanned.
197, Lordship, page 197.
Have they closed it?
No, Lordship, but they have put a iron chain, Lordship. So we have employed two gatekeepers to take care of that part, Lordship. So whenever trucks comes, Lordship, the gatekeeper open the iron chain and Lordship, but Lordship, this is not the final solution, Lordship, because
The final solution will deal with the final day. Not today. How can we go for
but
final
Lordship, they have
solution by an
again
interim
issued
prayer?
notice. Again, Lordship,
No,
they
madam,
will-
you tell me you want an interim order for a final solution, but this is not the final solution.
Lordship, either Lordship permit me to file affidavit in reply, Lordship, and Lordship, in the meantime, Lordship, interim order may be passed so that my client, Lordship, will not.
They are allowing you from 25/4. We are in the month of December. Then also you are doing it. Mr. Gupta, kindly chalk out a plan and work out what can be done in this regard as to means something has to be done. Yes, if it is has been all along, you have to man gates because manning of gates will require employment.
Yes.
So you have to talk with them and find out a solution because they are also to carry out some business. And you can't have manning of gates just like this. Because if there is a lot of transportation out there, Means you can't stop the train anywhere. You'll have far-reaching consequences. So the court to do anything is very difficult. You have to work it out amongst yourself.
Lordship, for a moment, kindly turn to.
No,
page
no,
157.
madam, nothing doing.
Lordship,
This
they have
court is,
admitted that.
no, nothing doing. First of all, this court is not going to interfere into all these things. First of all, you have talk it out, find out what is the solution possible, then come back. I may put a stamp of authority out there.
Lordship.
Nothing further beyond that. They are to run trains. How will they run trains?
But Lordship, they have admitted that merger can be done by providing alternate road connection. That is admitted in
Alternate?
alternate road connection,
You
Lordship.
do one thing. Why don't you ask them to make a flyover at your cost?
No, Lordship, it is,
Have a flyover.
we are ready to offer land, Lordship.
Oh,
but
you are ready to apply a flyover cost?
no, no,
No,
Lordship.
yeah. PWD may be there on
I-
both sides, and it is PWD will be there.
Yes,
It is where?
Lordship, it is in Sinamara, Johar.
Pinamala PWD will be there, and the portion above the air bridge will be done by them. They will make it at your cost. Best.
But even though, Lordship, if
You cannot stop trains like this. Nothing doing. That is why I asked you, why are you not filing an affidavit in reply?
Lordship, because there is urgency in what side.
Urgency will be there. But the problem you have to also see, how can this court impose, okay, you have a crossing there. That's none of the lookout of the court.
But
You
Lordship,
may have to move around somewhere else. Why you can't move around by this way? Is there no other route?
there are other routes, Lordship,
Then-
but that is Kacha Road, Lordship. It is not
Kacha road,
visible to
make
move
it pakka.
heavy traffic.
But crossing the railway line does not everyone will cross the roads. If we pass the wreath in this type of matter, means there's no end of it. Everybody will come to say, that, oh, that railway line is just in front of me. Just remove it. You're right.
600 to 700.
Tomorrow
lights
you are
at stake,
again
Lordship.
somebody has an accident. You will come and catch hold of the railways and say that okay, railway pay us.
That is why, Lordship, we are seeking man level crossing, Lordship.
You are
so
doing
that-
it. But madam, you kindly appreciate the far-reaching consequences of a direction being passed in these type of matters. This is absolutely within the wisdom of the railways. Was the railway line there when you had your industry?
Yes, Lordship.
Huh?
And after getting all the clearance, Lordship, from the concerned authority, they have permitted us to.
Did you take the clearance from the railways to
Yes,
cross?
Lordship, I have filed one representation day before, Lordship, in the year 2002, when the establishment was supposed to be there, Lordship. That time, Lordship, I have made a prayer that we are going to establish one unit, industrial unit. And they have also cooperated us. And from the last 2 decades, my establishment was there, Lordship. Around 10 to 11 industries are there, Lordship. 600 to 700 workers are engaged, Lordship. If, Lordship, the unmanned level crossing is closed,
Or if anything bad happens to those 600 to 700, you give an under indemnity bond that you are going to compensate the railways for making payment. We allow it. Even indemnity bond, that all expenses towards railway accident occurring because of unmanning of this particular thing, you are going to pay. I think you will be happy with that indemnification.
but
Even
Lordship,
undertaking.
provided, Lordship, the
Madam should have record that.
Lordship,
And Ms. Swain, appearing on behalf of the petitioner, submits that the affidavit will file an affidavit in reply to list this matter on 30th of 2025. The affidavit in reply be filed by 2025. Then an attempt will be made to the petition on the next day.
much obliged.
But madam, this is the problem. Talk it out.
Obliged.
28.
Find it today, you know. Yeah, for water is just.
And you have got a copy?
Yes,
see the copy, my lord. My lord.
Appearing on behalf of the Water Resource Department submits that an affidavit in opposition has been filed today. However, the same is not on record. Ms. D. Sunwal submits that she would like to peruse the same and thereupon file an affidavit in reply if so required. Urgency, no urgency.
I don't see my lord.
This is matter on 5th of February 2025. In the meantime, the petitioner would be at liberty to file the reply.
29.
Yes, same order. Same type of cases.
Lordship, in this matter, instruction I have received just few minutes back, I have received the instructions, Lordship. So sometime may be granted, Lordship.
For what?
For
We have made a very clear order last time. What is wrong? You can't delay the matter.
uh,
Mr. C. Sharma, the Standing Council of the Water Resource Department, seeks for an accommodation to stop. This court had made a very categorical order, passed a very categorical order on 2011-2024, directing the district administration and the Water Resource Department to apprise as to under which acquisition and under what acquisition proceeding the lands of the petitioners have been acquired. Full stop. Neither the district administration nor the Water Resource Department has filed the affidavit. Full stop. List this matter on 5th of February 2025. The affidavit, for the interest of justice, a final opportunity is being given to both the district administration and the Water Resource Department to file the affidavit on or before 27/1/2025. So the petitioner thereupon shall be at liberty to file a reply. This court observed that in the circumstance no affidavit is filed within the time permitted herein above, it shall be construed that the land in question have been taken away from the petitioners. This court shall draw presumption that the land of the petitioner have been taken away without the due process.
30.
That paper password for a time. I have filed my affidavit, my lord. Filed an affidavit, so they were directed to file an affidavit, in record the minutes of the meeting. Their affidavit has been filed.
You filed,
Yeah.
but
They
it
want
is
to
not on
reply, my lord.
record.
Yesterday, no, wrong way.
It has been, Mr. S. Bora submits that the affidavit has been filed in pursuance to the order dated 6/12/2024. However, the said affidavit is not on record. This is matter again on urgency, no urgency.
Urgency is there, Lordship, before we.
Urgency. On 10th of February 2025.
Very much.
You have not filed an affidavit on merits.
No, I have bought only the minutes of
You
the.
don't want to file an affidavit on
If
merits.
required, my fellow.
No, I am not required. He is alleging something you don't want to file, we will
The
consider you
minute
have
of
nothing
the
to
meeting
file.
has taken care of it. The minute of the meeting is I have annexed that have taken care of it.
This court have inquired with Mr. Esbora as to whether the respondents GMC would like to file an affidavit on merits. Mr. Esbora submits that no such affidavit would be required in as much as the minutes of the meeting would duly take care of
That may be before the month of January. In January.
it. I fixed the matter when.
10 February, no. 10 February.
What is the urgency? Huh?
From the point of contractual.
Contractual?
Bill.
March 3rd of March.
31 and 32
According
and
to-
connected item 57.
What is this?
Your lordship.
Such big files.
In the morning, we made a mention, same here, my lord, couldn't.
No, they are asking for objection. They are having serious objections against some stay you have obtained. What is the stay you have got? Let's see.
From against certain eviction, my lord, thereafter they filed an application for vacating the stay.
Wait.
And
Where's the stay order? Where's the stay order?
If lordship may be pleased to take up IA 355. IA 355.
No, there is not 355, 3551.
3551, my lord.
Yes, tell me where.
Their lordship may be pleased to come to page 82.
52.
82.
What 82?
82.
What is that?
The operative portion lordship will find at page 83.
Order fits into the projection made in the order. This court could not have granted the prayer for it.
Now, when the writ petition was moved, they made my lord prayer for interim protection. Nonetheless, my lord, at the initial stage, my lord, while taking up the matter at the motion stage, this honorable court was not pleased, my lord, to grant them any interim protection.
this is not correct, my lord.
Wait. In view of the above, it is provided that in the order dated so and so passed in 809, where is that order? Order dated 22/12/2022.
Now, they say,
The penultimate paragraph.
My lord, may just read the previous paragraph, my lord. Let us put the facts correctly, my lord.
The penultimate paragraph,
It's
it will be further read that the respondents are restrained from evicting the heir from the land under the occupation until
Let us
further
not
order.
mislead, my lord.
So there is a stay.
There is a
there
stay.
is a stay.
Correct.
Initially, and submitting that. They made a claim, but nonetheless, this honorable court didn't my lord,
This is, my lord, let us not mislead the court.
No, I'm
My
not
lord,
misleading.
No, Miss,
My lord,
Madam, first and foremost, no, Madam, first and foremost, he has filed an application.
complete my submission.
I
Then it
will allow you
my lord,
to point out,
my lord, I take my
to point out what Mr. Borpujari has misled. I'll allow you,
Then
don't
take a
worry.
call, whether I'm misleading or not.
Yes. What is this?
Since
Now,
my
what
lord
do you
had
want?
now,
What do you want now?
my lord, we have filed an IA, my lord.
For what?
For vacation of the interim
Okay.
order. Now, my lord, I'm submitting. This IA may be treated as our affidavit complete. We have already filed 2 affidavits. Matter pertains to, my lord, illegal occupation of part and parcel of government land, over which now, my lord, a 50 megawatt solar power generation project is going to be established. Now, my lord, things have started. Only because of this interim order, my lord, that things have not moved. We couldn't, my lord, go ahead with, my lord, implementation of, my lord, and my lord, constituting, my lord, that solar project. So that is the difficulty here. So lordship may be pleased to, my lord, dispose of this repetition today itself in the line of, my lord, Salahuddin, my lord. My lord, and Monmil Bolo, my lord, that TB hospital series cases, lordship has disposed of. In the same line, my lord. I'm only seeking that much. They will have a right of representation, my lord.
Where is the notice?
Notice, my lord, yes, notices lordship will file, my lord.
Yes, now let take a seat.
Yes.
Okay, yes, madam, argue.
My lord, I'm not ready for argument
No,
today, my lord.
then
That
2
is,
o'clock, get ready.
uh,
2 o'clock, get ready for argument.
My lord, there are 2
2 o'clock, madam, otherwise I'll vacate it.
My lord may do whatever this honorable court may deem fit and proper. What, my lord, it is harvest time and they had.
Madam, you see, recently, recently, there's a judgment in re-demolitions case.
I could not go through the judgment, my lord.
Not necessary, I know it. So there, in that judgment, it has been categorically mentioned that first, they will issue notice, which they have issued or not, I don't know.
They have not issued.
Okay,
Yes.
take it as a notice that you have come to know your notice. You submit your representation. After you submit, they will post it out there where the hearing would be there. After hearing, they will pass an order, and thereafter they give you 1 month either to file an appeal or do whatever it is. Nothing further beyond that. Thereafter, you go everywhere. Then at the end of the day, you will find us here. I'm waiting for that writ petition under 227.
Just because it's harvest time, my lord, that's it.
Harvest, no harvest doesn't, harvest, I'm not concerned. There's no harvesting time. Harvest, you get 1 month time from today.
Yes.
Harvesting, you see, harvesting has to be done on, you are SMEs people. Harvesting has to be done on or before 13th of January. Otherwise, we don't have Mag Bihu. We have the Mag Bihu because of the harvesting is done prior to that. So you do it prior to that. We still have, you can have to complete. Otherwise, to meet the deadline of Mag Bihu, you have to complete by 13th of.
That-
We have it
that's
at 2 o'clock.
My lord,
We are having it at 2 o'clock and give him a call, give her a copy of that medical judgment. That medical college judgment where I have passed an order similar to that, thereby you are protected. We'll take it up at 2.
that a little later after 2. My lord, there is some
Why?
witnesses from outstation, my lord, and I thought that this matter will come up, so I made a request to take it after lunch break.
Whom?
My lord, there are some witnesses from outside the state, my lord, and I cannot seek an adjournment there. So I'll finish up there maybe after 3 o'clock.
3 o'clock? No, 3 o'clock, I don't know.
Let
You
it not
give
be-
importance there. Go there. You can ask your junior to be there. This is the order which I am passing.
My lord, I'm just praying after,
You-
maybe after.
Madam, whatever you make your argument, this is the law. I'm protecting you. And whether you want, I can do one favor to you. At 2 o'clock, I'll start dictating the order. And I only one favor is I can put your name heard.
Let it be at 2:30, my lord.
2.
2 o'clock.
Ask those courts out there that you are standing before the court in High Court. The High Court, the courts will understand.
Or maybe, it's a 1 o'clock.
Absolutely at 2.
It's okay.
33.
I'm ready, my lord.
Me, please, your lordship.
Yes, what is this?
Lordship, till date, nothing has happened, your lordship.
Huh?
Nothing has happened, lordship, despite the last
All
order.
is ready, my lord. It will be delivered shortly, my lord.
Which one?
The
Disqualification petition, your lordship, that.
Oh,
period of
yes,
3 months ago.
yes. Why you have not passed the order?
it is ready, my lord. It will be delivered very shortly, my lord, within short span of time.
20, 20?
20, my lord, immediately after the vacations. my lord.
20, 20, 2012?
But,
Madam, kindly see, we are not bothered out here. Who is there? If he doesn't pass an order, it only shows that if he doesn't pass, I'm not passing any order out here. There's a clear indication by the Supreme Court that you have to complete it within a particular period. We have given you the liberty out here that you are going to take it. But don't take us for granted that because of that, whoever is the speaker out there, we are not going to pass an order. So ask them to pass the order by tomorrow. We are having it on 2012-2024. 2012-2024 is the date we are fixing it. Ask your person to pass the order. This is the matter on 2012-2024. In the meantime, the council appearing on behalf of the respondent, who is the speaker is respondent number?
1 and 3.
1 and 3, your lordship.
On numbers 1 and 3 shall obtain instruction as to whether the passed. You have to pass the order, nothing more than that. Don't embarrass your position.
I'm obliged.
Yes, madam.
Lordship, they have just filed an affidavit annexing a gazette notification of a rule amending the settlement rules. I may just have a day to go through it, Lordship.
What?
File an affidavit, lordship,
What affidavit?
regarding on that notification, lordship.
Which notification?
Notification dated, lordship.
Madam, you want time?
I can, just one day to read this properly, that's all I want.
I'll give you 6 weeks for that.
Should not 6 weeks, let it be, I mean,
6. Not. An affidavit has been filed by the respondents. You are revenue?
Yes, lordship.
By the revenue department, so-and-so appearing on senior counsel appearing on behalf of the petitioner submits that you'd like to.
Affidavit, we have
go
filed
through
an
the same.
affidavit on 13/12, lordship.
On not on record, Lordship.
Has been filed on, it has been submitted as an affidavit in opposition. Department on 13/12, in which writ petition?
In WPC 4855 2020, Lordship.
In 4855/2024. However, the same is not on record. Full stop. The registry shall bring on record the said affidavit. Full stop. Miss So-and-so, the learned senior counsel appearing on behalf of the petitioner, that she requires some time to go through it and also obtain instruction as to whether they would be, the petitioners would file a reply. List the matter, 6 weeks.
If they apply.
62 to 66.
Lordship, here regarding the PHE money, which PHE doesn't pay, I think the finance was asked to give a definite date on what, as to when they'll pay the principal. I'm not talking about interest right now.
PHA is not paying.
As usual, Lordship.
Hello?
And the finance was
So we
supposed,
fix it for final disposal.
yes, along with the interest, Lordship.
Huh?
Yes, and the entire matter. Yes.
So, Miss M. Hazarika, the learned senior counsel, appears on behalf of the petitioner in the batch of writ petitions. Batch of writ petitions,
Yes.
or are they contempts? Oh, one,
I-
two writ petitions.
Petitions and
In
contempt
the
matters
two
are
writ
there.
petitions. Full stop. Miss Nunn appears on behalf of
I
the
appear for the finance. Lord.
PHE department on call. Mr. B. Gogoi appears on behalf of the finance department. Full stop. It has been submitted by the learned senior counsel that there has been no, the PHE department has not proceeded further with the negotiations, and there is no likelihood of any settlement out of court. The senior counsel therefore submits that the matter may be taken on an urgent basis for disposal. Is this matter on 6th of February 2025. First of all, it is observed that on the next date, an attempt shall be made to dispose of this.
For orders, item 34.
Well, we have filed a affidavit.
The paid,
Payment to the tune of 1,78,000 has been made and it has been deposited to the account of the petitioner. And he has given admission also, my lord, that pays
Okay.
330.
no, that is okay, but monthly is he getting?
What?
Monthly is he?
Till August we have paid it.
Okay, but monthly you do it,
Yes, we
otherwise
have
how
to
will
do
they survive?
Yes, I will have to do that. And my lord, regarding that, my lord,
And if you don't do it, then we may have to compel you to pay the remuneration of madam also. She has been unnecessarily dragged. Yes, madam, there was another matter today pertaining to a similar matter which I have taken up yesterday, where I had said something to Mr. M. U. Mandal. Remember, for not taking steps in it.
Yes, sir.
This is a similar matter. One needs to address on the question of clause 7. Can you restrict it by within 1 month?
Lordship,
So
if-
I think
if
I'm
we-
fixing that on 29th of January,
20?
9th of January 2025. We just will, on that point, we will hear, because that matter and this matter have been tagged together on that.
There's only one particular clause in 357A which talks about a time limit, which is 357A4, I think, if I'm not mistaken, which says 2 months. But if we go by the basic interpretation of statutes, then
No, it's a-
perhaps
it's
this
a
scheme
welfare.
is it's actually a very loosely drafted scheme, Your Lordship. What should I say? It is our own, I mean, the state government has really drafted it in a very loose manner. So there are a lot of loopholes in the entire
So
scheme
that day,
itself.
I will try to hear that matter on that issue. Because this is everywhere happening. Because there are many cases, like in that case, they were interpreting from the date of the judgment. But if you see 7 only from the date of the crime.
Becomes a little difficult.
And anyways, here, what to do?
Lordship, the only other thing which needs to be addressed is perhaps the fact that they're now asking us for a caretakers.
an undertaking saying that we are appointing a caretaker for the child, which we are not, Your Lordship. We do not have the capacity to engage a caretaker. It is the mother who has been the primary caretaker of the child. And she also used to do some hajira kind of things and work in families at places. But now she's not unable to do that. So perhaps if Your Lordship allows us, they have asked us to fill up a form. And what we are planning to do is fill up the name of the mother as the primary caretaker and open a separate bank account in her name. If Your Lordship gives us that permission, then perhaps that can be taken care of, because they are saying
That would not be proper. That would not be proper.
3,000 rupees, no one is going to come and work. for
Madam,
us.
in the open court to say, suggest that would not be proper. Whatever you know what is to be done, find it out what is to be done. The question of allowing the mother to be the caretaker means you are asking the mother to.
Private caretaker since day.
Understood, everything is understood.
Yes, Your Lordship.
But the caretaker aspect has been given so that there is maintenance of a continuity. You see, tomorrow the mother may not be there. So for that, we are taking into consideration a caretaker would be required. That is why that very aspect has been mentioned. Now to make the mother the caretaker out there and thereby the mother getting that money would not be proper. So I think you can very well advise your client what to do.
Rashmi, give me some time on that, but otherwise, yes, he's correct that we have
Okay,
to follow the
list this
primary.
matters. List this matter. Mr. Bigogo appearing on behalf of the health department submits that an amount of rupees 1,78,000.
1,78,404.
404 have already been paid to the account of the father of the to the petitioner for the well-being of the child, of his child. And so he further submits that the process of making monthly payment as directed by this court is also being undertaken so that the same can be regularized at the earliest. List this matter on 10th of February for an update.
Deeply obliged.
You advise your client properly.
Deeply obliged.
And then they will give you 30 days time. I didn't I mention 30 days time? There you can file an appeal. And this is how you have to proceed.
My lord, only one, if I may make a prayer, in paragraph 50 of the judgment, 50, in paragraph 50 of the judgment, that is a directions, in fact, in clause 3 of that judgment, 30 days to file representation is given. Can 7 days extra be added in view of this Bihu means a harvesting time, and just 7 days extra if it can be given.
Harvesting time, why?
This 30 days time in the judgment, my lord, paragraph 50 in clause 3, this honorable court has given 30 days time. Whether this 30 days, another 1 week can be added. I leave this to my honorable court, my lord. If it can be added, my lord.
30 days, 30 days.
My lord. And then another fact, my lord, if can be noted, my lord, in the affidavit filed by the state, my lord, at paragraph page 794.
Tell me.
Page 794.
Yes.
My lord, there they have mentioned about allotting some alternative land. It is in their affidavit. That fact may be recorded only.
No, you see, madam, there is another thing. If the government says that they are going to give you alternative land, better why don't you explore that opportunity better than to stay there? What have you done? You are harvesting only.
No, we have our homes also, my lord.
Homes, they will take care of that. What type of homes you have? Where is the land?
Residential house with our family and children.
Where is your
we are
land?
studying.
We are having my lord thatched house only. We have annexed the photographs in the eye also, my lord.
Whatever house is house, my lord. Somebody may be a little more lucky.
House is okay. If they are giving you alternative land, let them give you alternative land until then not to evict you.
Yes, my lord. In fact, the decision was taken in the SDLSC meeting itself. 30 because of alternative land has been earmarked for them. They are not shifting there, my lord. They are
They have earmarked land.
30 bighas. 30
In
bighas of land, my lord.
page 794.
Where is the land? I'm not getting where. Page application for modification. Where is that land?
Yes.
Where are the photographs?
Lordship, may be pleased to kindly come to page, my lord, 84. 84 of the IA. The description of the land is there, my lord. Is the extract, my lord, of the SDLSC meeting.
Where is the present land?
The present land is, my lord, at
It is 30 bighas in dark number 378.
yes, and the present land is measuring, my lord, 864 bighas, 2 kotha 11 lessons of village number 3, Sitalmari.
And all of them are in occupation of that.
Yes, my lord, some of them are now in occupation. Now, what has happened way back in the year 2021, notices were issued. These are part of the petition, asking them to vacate. Then, my lord, by passage of time, my lord, those notices were not immediately being acted upon. Now, my lord, some of them have voluntarily left. Now, again, they came into occupation. After that land was
How much
earmarked,
land they are in occupation?
they are, my lord, in occupation of, my lord, they're scattered, my lord, in these, my lord, 864 bighas, 2 kothas, 11 lessons of land, my lord.
They are in occupation.
Not in the total land, my lord, they are scattered, my lord. But the total area is, my lord, that 864 bigha, 2 kotha, 11 lesser. Now,
And what right do they have?
so they do not have any right. Even they have not even applied for, my lord, land settlement. There are no document on record, my lord, to show that they have applied for land settlement or allotment for that matter. Now, if please,
Since there was a proposal to dispose
Page-
of in terms
page-
of this
page
matter, I'm not
104,
placing it
page
on.
one-
But
merit.
these are dark number 91.
my lord,
This is dark number 91.
yes. Darks, my lord, there are various darks, my lord.
So these are all dark number 91 and 76.
Dark number 91, 92, 93, 94, everything is there, lordship. If
All these 154,
yes.
76.
Yes, these are all government land. These, my lord, all these ducts, my lord, comprises of a total land measuring, my lord, 864 bighas. That is what is to be found, my lord, at page 90. That is, my lord, handed over, my lord, to APDCL for setting up that, my lord, solar power generation project of 50 megawatts.
Where is it?
Page
Where is the
90,
document?
Page 90 of my IA, of the IA. Page 90 of my IA.
And the petitioner are in occupation of all.
They are scattered. They are scattered in, my lord, that entire my lord, plot of land. To that extent, lordship will find.
And where have you stated in your affidavit that you are going to allot that land?
Yes. That in fact that decision of SDLSC is also a part of, my lord, this IA. If lordship may be pleased to come to page 84. Page 84 of that IA.
That is you tomorrow you are not going to honor SDLAC. You may say that
There are-
SDLAC, who is SDLAC?
Page 28. Lordship may kindly come to page 28.
Of your IA?
Yes, yes.
Yes. Tell me.
Before that, my lord, page 27. Paragraph 5 is of importance, my lord. Let me read it, my lord. Page 27, paragraph 5. That the applicants respectfully said that a government land parcel measuring 864 bighas, 2 kotha 11 lessers, so 285 acres located in number 3 number Chitalmari village under Borsala Mouza of Bhekiajuli Revenue Circle, Sonitpur district, has been identified for setting up of 50 megawatt grid connected solar PV project by so-and-so under the supervision of APDCL with a total contract value of approximately 350 crore and expected completion date of August 2025. The Honorable CM of Assam on 10th of March 2024 laid the foundation stone at the project site, and the said project shall contribute significantly to the power sector of the entire North Bank landscape of Assam. That the applicant state that the aforesaid government land and parcel was illegally encroached before handing over to APDCL, and accordingly on 3/9/2022 an eviction drive was carried out in 3 number Chitalmari village to make 864 bigha 2 kotha 11 lesa government land enforcement fee. Consequently, a Gopchar land measuring 30 bighas in Dag number so and so has been earmarked for rehabilitation purpose of the aforesaid encroachers, but the encroachers have not shifted their temporary shelters to this allotted land.
Where is the allotment?
My lord,
Where is your allotment?
allotment, my lord. With
Where is
regard-
your allotment? Allotment has to be on the basis of some order being passed by the governor. Where is it?
That lordship will find at my lord, in the writ petition, my lord, an affidavit was filed. That affidavit, my lord, if lordship may be pleased to come to page number, running page number 797. In the writ petition, my lord, running page number 797. This is, my lord, the reservation order of that 30 bigha of land. This is by the government to the deputy commissioner. Proposal for reservation of VGR land for rehabilitation of families affected during the eviction drive carried out on so-and-so in 3 number Chitalmari area under Dhikiajuli Revenue Circle regarding. This has been done, my lord.
The direction conveying approval of the governor to initiate the reservation.
We were therefore requested to initiate reservation proceeding to the aforesaid land under.
No, this
so-and-so.
is, you are in the process.
But that
Where
land-
will you go tomorrow?
Otherwise, my lord, that land has been earmarked because there are other lands which were found by the authorities that it may not be suitable for human habitation, is a low-lying land. We have identified, my lord, these certain parcels of land which are readily habitable, my lord. And so it is a part of, my lord. And therefore, my lord,
So this land you are going to give, not for agriculture purpose.
no, it is only for that because
No, for what purpose are you giving?
for their rehabilitation. These people who are who came into occupation.
How many people are in occupation? How many families?
My lord, almost, my lord, now it is almost. Then again, my lord, I'm traveling, my lord, lordship may be pleased to come to para 5 of my IA. Para 5 of my IA, my lord. That
Yeah.
my lord, at page 28, which I was just reading, my lord.
You are saying that they are not shifting. First of all, you have to give an allotment to shift. With your order of allotment.
That SDLAC, my lordship will
And
find.
are you going to give all these 146 people go inside these 30 bighas? You have to give specific allotment to them that this is the area we are going to give you. The allotment, kindly go there. Without that, how can you?
Lordship can also direct, my lord. Lordship can, to that extent, lordship can direct, they will complete the.
Therefore, my question is,
Yes,
you'll be exercising your powers under the Assam land policy. You're exercising the power under land. Then how much land would they be entitled to?
1.5%.
For Guwahati?
It is not Guwahati, it is rural.
Either it is rural, so rural does it 1.5?
1.5.
5 bighas.
It is 5 bighas, but 5 bighas here, my lord, for residential purpose, my lord.
For residential purpose.
Here residing there, my lord.
Cultivation primary, but we are having
Cultivation,
our
you have no
residence.
business. What cultivation you have to make in government land? Show me your right that anybody can go out there in the government land and cultivate.
1970,
70 or
70, then
let us
1960.
assume that you are doing not in 1903.
Now, in the affidavit also, my lord, in the main need petition at page 794, we have spelled out. My lord, that detail and so and so, my lord, a total of 299 families were evicted on 3/9/2023, and out of those, 45 families were found to be landless. 45 families were found to be landless. Accordingly,
Others have land. You don't have land.
No, we have the land which we are in occupation. That is the land.
They are only using it for cultivation.
We do not have
Madam,
any other land.
that cannot be said to be your land.
Exactly.
So and furthermore, you cannot occupy whatever you feel like.
But we have been settlers since 1970s.
Settler means how?
1980s.
How?
Why not we have as permissible occupiers, man. Permissible occupiers,
How?
man, paying Tozi Bahira.
Tozi Bahira doesn't mean that. Tozi Bahira is a penalty.
My lord is well aware, my lord. All land in Assam is government land.
All land in Assam is government land, provided you are given a settlement.
Exactly. And our applications are pending till today, not disposed
Show
of.
me one of your applications in your writ petition.
Yeah, we have stated in our affidavit, which after the filing of the writ petition, we gave formal under that Vasundhara. Earlier,
Where is your affidavit?
Vasundhara, my lord, we have stated.
These are applications which are pending.
Yes. In it page number is a page. It starts from page 608.
Now 300 days is long over.
Yes.
Then what happened? This possession at page 626 is from 1/3/1993.
Yes, there are several. I'm saying from 1917 onwards, then and whatever till the even if it is 1993, my lord, it's 20 years now. And my lord may kindly consider, we have a right, being the citizens of India, right to live with some dignity, some safety, my lord. I'm not saying don't go with the power project. I have also advised my client that if you get some alternative, you will have to take that alternative. Then you cannot fight to be in
You cannot have the same quantum of land which you are there.
I have not asked for.
You may be entitled to get 30 bighas of land, Mr. Construct a house. Take the HRD's thing and construct a 10-story building and give one flat to everybody. Matter over. Need a shelter, then do other business.
Yeah, we need shelter, my lord. At least that. Now, my lord, because of the writ petition, my lord, because of the writ petition, I may just point out one thing, my lord, how inhuman we can be. Even the deaths that have taken place, they are not, if the Gambura has been instructed not to give death certificates, my lord, can we be this inhuman? Because of the pendency of the writ petition. This is something bizarre, my lord.
Not part of the petition.
This is something very bizarre.
I am taken by surprise. I am taken by surprise.
Yes, that is what the government is taken by surprise.
Part of the petition. I did not have the right to traverse. Now here, my lord, in the IA.
Death certificate, what are you going to do, Mr. Revenue?
God knows what they are going to do.
Death certificate, let me ask Mr. Dinath. You have nothing to say. The revenue has no business out there with regard that certificate.
Gambura instructed, this was too much, my lord.
No, whatever may be, madam, first of all, it is a project of the government. You need to dedicate it.
Even the human beings are
Dedicate it, and that area, only thing why I don't want the entire matter to go more prolonged. Mr. Barbudari,
My lord, the projects, we understand, my lord, the projects
Mr.
are for human
Portugal,
beings, my lord.
First of all, how many people are there with you?
207 families. And my instructions are there are about in that area 300 families, but I cannot say about 300 families.
There are-
But we, before the honorable court, we had 207 families.
Are you all indigenous?
Yes.
Here we see only 146 petitioners. How many petitioners are there?
207.
207.
207.
Out of the 207, my lord, only 45 are now in occupation.
No, no, kindly come. 143 and 144 petitioner. 143 is Abdul Khalek. 144 is Noor Mohammed, son of Abdul Khalek. What is this?
143 and 144.
See this?
Abdul Khalid.
147, son of Makar Ali. 148, son of Makar Ali. 149, son of Makar Ali.
They are married. They are married and they
Married.
have families, my lord.
Happen like this.
Well, the fact, whatever is the fact, I'm
These
stating,
are very
my lord.
serious things.
And I am not saying that they be given equal quantum of land. That even I understand, my lord. But they will live somewhere, my lord. Where in the earth they cannot go to the sea or to the ocean, my lord.
No, my lord, the current position of occupation by these encroachers, that is reflected in my lord, in my IA page 104. Kindly see, my lord, in my IA. That is the map. That is the map prepared by the authority, revenue authority. And I have the original map. Lordship may kindly peruse this. The black rectangular spots out here, my lord, are being occupied by them.
So this the entire area would be given.
So the entire area is earmarked for that project. And in that area, my lord, in that superscribed area, my lord, Lordship will
This
kindly-
entire area,
Yes.
which area is being given? This is the entire in
Yes.
number.
No, this is the plot of land, my lord, which is over which they are-
Silombari.
Yes, now this is the plot of 864 bigha, which is earmarked, my lord, for that project. Over which, my lord, these black spots, lordship will find, rectangular black spots in the middle
Is there any reason to put it in black?
for identification. Now,
There is, my lord.
so, it is, my lord, for the purpose of, my lord, identification.
No,
There are other colors.
Identification, you have to violet, green, orange, white, everything. But why the
Done by
black
the-
spot against these petitioners?
My lord, it doesn't, not meant to be that way, my lord. But otherwise, my
I
lord,
hope you don't want to go into the literal meaning of that.
but lordship will see, my lord, over that entire area, these black spots, these are in occupation. And these are, my lord, thatched houses, temporary center houses. They are basically in occupation of this land for.
So
for
what
the
is
purpose
happening
of
to the
cultivation.
model school and LP school?
No, we are not touching that.
This is a part of that land.
This is a part of that land. But the project will be set up because it will be all, my lord, solar
The
panels.
project has been given in which dark?
Project is being given, my lord, in the entire land. That is,
So this includes the LP school and the model school.
yes, the entire land, that, my lord, page 90 of my IA. The handing over, taking over. There are various ducts, my lord.
And when did you take steps for allotment to this particular APDCL?
It is, my lord, in the year 2022. September 2022.
And thereupon they filed the application for settlement.
Yes.
They
There,
filed the application for settlement in 2023.
yes, thereupon.
So in the
Only after
meantime,
filing of the
so
petition.
this very land was already there under 18.2, it could come within it, taking into account that these lands happens to be the allotted for specific purpose.
That for specific purpose.
That allotment is
Now, therefore, lordship
subsequent,
will
my
see
lord.
in the map, because it will be a solar project. In the, my lord, it will be laid down horizontally, my lord. Those solar panels will be there. So definitely the project will be set up in the open area. And they are in occupation by doing cultivation.
they're doing cultivation out there. They have their residences in some other places. They intermittently come, they say, stay there in cash houses, therefore this submission is forthcoming. Let me harvest, let me harvest.
Harvesting, no harvesting, what harvesting?
I'm just, madam, assisting the foreman.
Those harvesting crops come to our houses only, my lord.
Harvesting, you must have done it. You see anywhere in the fields out there, you go anywhere from here, Guwahati to Dhemaji and or Guwahati to Dibrugarh. You don't find any more further harvesting now.
Till Bihu, my lord, it goes on, my lord. There are a lot of crops, my lord, this time.
Okay. I just got transferred from Patna here. I'm here, I've been a resident of Assam, madam.
Yeah, I know crops. I'm not saying rice crops. It may not be rice crops.
My lord, in the, I'm traveling, my lord, on these pages. In the petition, my lord, at running page number 800, we have annexed the photographs. It is well fenced. One portion of the fence is kept open for ingress and egress, my lord, of my lord, these officials, my lord, to go and set up their, my lord, tools and machinery for starting the project. It is through that, my lord, passage, my lord, they are entering. Overnight, they are entering. They construct houses. They start digging that and, my lord, some cultivation.
But how do you think of accommodating these people?
Now there are only 45. Therefore, I have given the latest map, my lord. What is before my lord is the latest position, my lord. Those only some intermittent spots. Otherwise, my lord, most of the people have voluntarily, my lord, they have vacated.
That is not correct, my lord. I have my objection to this file, my lord, to this, I filed an affidavit. Perhaps it is not on record.
Now it is, this entire area is enclosed
No.
by a fence.
Well, almost, my lord. Almost only in some part, my lord, there are small passages, my lord.
No,
Right,
the passage is okay,
Yes.
but
Ma-
is it
yes, yes.
enclosed, circled out?
Fence.
So this 864 bighas is circled out.
There is 2000 bigha of land in that area. And so far as the fencing part is concerned, this honorable court will get a clear picture. If it takes up that contempt petition, there is a direction.
For what?
Like if the children and everybody, women, children, everybody inside the fence, and they had to climb through the fence to go to the school. And there was an order in the.
Where's the fencing in this map?
Yeah.
It is in its contempt is there,
Fencing,
my
my
lord.
lord, if lordship takes up the writ petition at running page number 100, the affidavit filed by the deputy commissioner, district commissioner, my lord. The photograph showed the fencing.
100?
Yes.
What 100?
My lord, 800, my lord.
800.
Yes, page 800. Running page number 800 in the writ petition. There, lordship will see, my lord, it is fenced.
Ah.
My lord, there is a road.
Huh?
Page
Ah,
800,
road.
Page 800. On the right hand side, some people are there, my lord. These are outside the fencing area. They are having their houses there.
Outside.
Yes, outside.
And what about the inside houses?
Inside houses, my lord, these are temporarily set up, my lord.
And you see a big tin roof out there.
My lord, it is,
No, page 800.
yes, but
See a tin roof.
no, it may appear to be
It
tin,
can't
my
be
lord.
thatched houses.
No, my lord, these are,
801 also is there.
these are temporary construction, page
With tin
801.
roof, proper tin roof. See the height of the building.
The height of the building, lordship
This
is
must be, this has to be an, having the RCC linked along with the, this thing, tin roof.
lordship may kindly come to the next page. Kindly see the next page.
Mm.
Kindly see, my lord, these houses.
These are thatched houses.
Yes, most of the houses, my lord. Then page 802, lordship will kindly see the next page. This is the passage. This is the passage. Over for which, my lord, they enters.
And you are saying that the inside area is there,
Yes,
inside area.
Yes,
So they
yes.
have a lot of cultivation there.
Yes, they are doing it, my lord.
Yeah.
They come, my lord, my lord, all these are being done, my lord, after they got my lord, interim protection from the honorable court. And we have categorically spelled out that in our affidavit. In the garb of getting interim protection, that there are no coercive action should be taken against them, they are happily cultivating, my lord. Unless and until, my lord, that order is vacated. Therefore, we have filed this IA. Now, my lord, in view of Salakuddin and Lordship has decided, my lord, this medical college hospital series. Law is settled, my lord. We cannot tell her.
Mr. Borpuzar, me passing that order is not a problem. It is not going to help you out. It will further derail the process. That is why I am not on that. I could have very well passed that order. It will take 2 minutes.
Yes.
If something can be solution by which you give it to them, the allotment out there, let them go to just check out as to whether they are having out there any houses or the indigenous people and all, and then they give them that allotment in the 30 bighas of land. But it has to be all allotment made specifically to the persons concerned who is entitled as per your land policy.
Absolutely. I'm so grateful.
So,
I'm
so
so
the
grateful.
petitioners herein cannot claim a right to remain in government land. There's no right they have over the government
Per
land.
se, per
But
se.
only thing is, they are entitled to be considered for the purpose of settlement.
Yes.
Taking into account that they have wastelands and they are there now, government has taken a more of a benevolent stand to the effect that they are going to rehabilitate these petitioners, the persons who were there inside.
Yes.
So under such circumstances, you have to do. Therefore, first of all, as I could see, many of the petitioners seems to be a duplication.
Duplication.
Duplication, like everybody, they have put all the brothers out there.
Therefore, my lord, this number of petitioners have, my lord, showed up.
Well, it seems to be duplications
Yes,
out there. So
yes.
under such circumstances, you have to allot a plot of land to that effect. So the allotment of a plot of land cannot be for farming.
Yes. It will be only for residential.
Residential.
Yes.
Taking as a welfare state, you are giving it for residential.
Absolutely.
Now for residential, it will be 1 katha 10 lechas.
Yes.
So 30 bighas will be how much? 150.
150.
150 kathas. So it will accommodate how many? It has to be less than it will be less than the number of petitioners.
Yes. Therefore, my lord, we have.
How do you take care of that situation?
No.
That is the only worry I am.
Yes. Now we say, my lord, that as of now, my lord, there are 45 families. 45 families. And to corroborate that, my lord, we have prepared that map and placed it for my lord. It's a part of our IA also. Now, those 45, for that 45 families, 30 because have been earmarked. This is our clear pleaded stand out here. Because they are found to be in occupation. Others have left or there are duplications which lordship has said. So the authorities out there on a field verification exercise have found that there are 45 families. Now, as per my
As all the petitioners herein, each of the separate petitioners herein, madam, have enclosed payment of tozi
no,
separately.
I do not find as such. They have enclosed. They have enclosed.
Yes.
Randomly.
No, not randomly. All the 207
Yes.
petitioners have submitted one document also to the
Yes.
that they are separately paying.
From page 266 onwards in the writ petition. From page 266 onwards. And
Because that is a relevant consideration to be looked into.
Yes.
That are there a case of duplication or not?
direct part of the authorities will carry out.
No, that I will direct.
Yes.
Only thing why I'm worried out there, just for example, you see in all these things which they have enclosed.
Well, if you start with 266 is Kalicharan Mandal, then 269, my lord, if it's not very legible, we can have the type copy is Dukhiram Biswasi. Then
Show the names of the petitioners number 147, 148, 149, and 150. Where are those? Because here these are all duplications of one Mongol Biswas. Ranjit Biswas. I don't think there is anybody of Punya Biswas doesn't have.
Noor Islam also doesn't figure out here. I'm looking out to.
Check and
Noor Islam, it's petitioner number 147. From page 266 onwards, my lord. To page
that
403.
cross check and give a list.
266 to 403. My lord.
Two 273 to 404 are all receipts.
Yes, my lord. Now, so far as 147, P147 is concerned, Noor Islam, I do not find any Todi Bahia receipt here. Noor Islam. The random.
Let's dispose of this. Heard Ms. B. S. Goeltel and his counsel appearing on behalf of the petitioner. Mr. Arbo Puzari appears on behalf of the Revenue Department of the Government of Assam. Who are you?
Colleague is appearing.
Let us not touch that.
APDCL, I am the.
Okay, you want to press that petition, I will allow that and then give you time to file affidavit. If you want that, okay. You want that?
For respondent number 2, 3, and 4.
It's Dina appears on behalf of the respondent number 2, 3, and 4.
My lord,
207 petitioners have joined together to file the present writ petition challenging the eviction notices issued. Have, madam, have all eviction notices been issued to the name of the petitioners? No.
it is there.
No. Have it been issued to all the petitioners?
Yes, that is why they have been put this
So
on.
thereby you are acknowledging, are you acknowledging that the petitioners are in possession of those lands by way of a notice?
Therefore, my lord, in my affidavit, we have said, we issued notices.
To all the petitioners.
It was not acted upon. Nonetheless, it was not acted upon. Most of them have left, and now, my lord,
How many eviction notices are there, madam?
eviction notices, lordship will find from page 406 onwards. In the writ
405
petition.
onwards.
Yes.
Huh?
From 405 onwards. And my lords may also take notice of the contents of the notice. In that notices, they say that you have houses, cultivation, and you may remove. They
That
say
is
in
what
the
I'm
notice.
saying. Are you not admitting to that effect? That they are in occupation of such huge tracts of land?
They were in occupation, but the case is such, my lord, that by passage of time, most of them have voluntarily left, my lord. Once they came to know about this project, And once this handing over fencing, everything was done. Now, my lord, this
Hello.
45
I've
families. are
challenged the eviction process. Initiated by the circle officer Dhekiazeli by issuance of eviction notices to them all dated 15/11/2021. In addition to that, the petitioners have also sought for a direction that the lands under their possession be settled by the respondent authorities in terms with the Assam Land Policy 2019 on the ground that the petitioners are indigenous persons, indigenous landless persons entitled to settlement. The claim of the petitioners herein Hello. Hello. From a perusal of the writ petition, it is seen more particularly at paragraph number 4, seven, that only details have been given insofar as the petitioner number 1 to 10, 1, 2, 3, 4, and 10, 1, 2, 3, 4, 6, 9, 6, 7, 9, and 10, 8, and 9, and 10. But the petitioner, but the writ petition is otherwise silent in respect to the credentials of the other writ petitioners. It is further seen that in Annexure A series and Annexure B series to the writ petition, voter cards as well as NRC extracts have been enclosed.
In the voter cards, my lord, their addresses are shown to be some other places. Kindly see. For example, at page 189, my lord, it is shown to be, my lord, resident of number 1 Horolu, so and so, subdivision Tezpur. So therefore, they have own residences.
This court have duly perused the Annexure A voter cards, wherein addresses have been duly mentioned of the respective petitioners. However, it is seen that in respect of that it is only in respect to some of the petitioners it has been shown that their addresses are at Chitola Mari, Nonke.
Same address. Chitalaman.
Huh?
At same Moza, my lord.
No,
Same
Moza is different, madam. Madam, kindly listen. Your case is 3. We are concerned with 3 Chitolamala. I am giving you the advantage. Just for example, kindly come to page 61. Yes. It is 2 Chitolamari, which is a different village. Okay. Now kindly come to this one. Page 93. This is different address.
Is most
Kindly come to page 104. This person resides at Morigaon. Kindly see.
Therefore, my lord, petitioner number 122, Suresh Biswas. Petitioner number 122, Suresh Biswas, lordship, kindly see page
This is,
163.
I have given this, my lord, I am aware of this. Some
Aadhaar card.
one person may be staying in some place, but they may not have his homestead there and has cultivable land. Some people have the cultivable land
So
and the
therefore, madam, first of all, you should have chosen when you are filing a writ petition for 207%, specific details has to be provided. It cannot be in such a manner. You shouldn't have. You have just see it is only in these paragraphs you have stated about petition number 1, 2, 3, 4, 5 is not there. 6, 7, 8, 9, 10, and rest you have just normalized, given a generalized.
with an army with or the bulldozer and knocking at the door, my lord, it was in this rush that the writ petition was moved.
Very well, whatever may be. If you are a lawyer, if you are a professional, you have to be professional.
Petitioner number 122, lordship will kindly see page 163. This is the Aadhaar card. Aadhaar card is, my lord, given on the basis of permanent residence. In Morigaon.
Be it as it may, it is further noticed that from Annexure B, which are extracts of the NRC, also do not show that only shows that only in some of the petitioners are residents of village Sitolamari NK. Full stop. This court have also taken note of Annexure C of the writ petition, which are some of the revenue receipts pertaining to payment of penalty on account of occupation of government land. bracket Tozi Bahiri. And there appears to be no correlation specifically in the pleadings with those documents. Annexure D are some of the eviction notices dated 15/11/2021, which the petitioners have challenged. Pertaining to the initiation of eviction proceedings initiated under Rule 18 of the settlement rules framed under the Assam Land and Revenue Regulation 1886, for short, the regulation. In addition to that, this court have also perused the affidavit in reply so filed by the petitioners through one Bimal Sarkar on 15th of March 2024. It is interesting to take note of that this deponent, the deponent of this affidavit in reply, is 45 years old. As on 15th of March 2024. And statements have been made in the affidavit to that extent that some of the petitioners or their ancestors have migrated and have been residing in Chitalmari revenue village between the period from 1970 to 80. To the same at the affidavit in reply, it is further seen that the petitioners have also applied for allotment of settlement under the Bosundhara 2.0 government scheme. And those applications, along with the acknowledgements, have been enclosed as Annexure E series. From a perusal of those applications, it transpires that all these applications were filed sometime in the month of March 2023. Be that as it may, there is no correlating pleadings, the pleadings to the effect that these applications are vis-a-vis those petitioners specifically. be that as it may, the case of the petitioners herein, as would transpire from the pleadings, that the respondent authorities cannot evict the petitioners by following the due process, meaning thereby without adhering to the principles of natural justice. Ms. B.S. Goel, the learned counsel appearing on behalf of the petitioner, submits that these petitioners submits that though there has been certain laxity in the pleadings, but the fact remains that all these petitioners have been in all these petitioners or their predecessor in interest have been in possession of the land since 1970-80 by carrying out by residing therein and carrying out cultivation. He therefore submits that one fine day submits that the filing of submits that the manner in which the respondent authorities, more particularly the circle officer of the Dikhiazili Revenue Circle, have initiated action. Thereby asking the petitioners to vacate without giving any opportunity of hearing, and that too without considering that the petitioners have also rights to be granted settlement. Requires interference from this court. And more particularly in view of the recent judgment of the Supreme Court in the case of INRI demolition, reported in 2024 SCC online, so and so. The Learned Counsel further submitted that in terms of the recent judgment of the Supreme Court, which is now a law within the meaning of Article 141 of the Constitution, the respondent authorities have to give a hearing to the petitioners, as well as also an opportunity to avail other remedies in the circumstance any order is being passed against the petitioners. Per contra, in the backdrop of the case of the petitioners, let this court now take note of the stand of the respondents. The stand of the respondents could be seen from the affidavit filed by the respondent number 2, as well as the interlocutory application so filed and registered as IA 3551/2024. Where is this affidavit now?
That starts, my lord, running page number 791.
Huh?
Running page number 791 of the paper book at my lord of the rate petition. This is the second affidavit. Initially, an affidavit was also filed, my lord. It starts from running page 602. Lordship may be pleased to take up the second affidavit, my lord, from running page 791 onwards.
602, got it.
This is the first affidavit, my lord. This is only a very short affidavit, my lord. Thereafter, a detailed affidavit was filed, my lord. It starts, my lord, at running page number 791,
Okay, let me come back.
my lord. The writ petition, my lord, running page number 793, my lord. That is the second affidavit. filed.
See from the records that an affidavit in opposition was filed on 17/6/2023 by the Deputy Commissioner Honitpur, wherein it has been stated that most of the residents are illegal encroachers of government land falling under number 3, Sitalmari Revenue Village. It has also been mentioned that the residents have been evicted for the purpose of setting up solar plants to generate electricity, thus pushing the idea of clean energy. It was also mentioned that the eviction was carried out in terms with para 15.1, 15.2, and 15.3 of the Assam Land Policy 2019. It is further seen that subsequent thereto, another affidavit has been filed on 20/5/2024. Wherein it has been mentioned that a plot of government caste land measuring 1,000 bighas at Sitalmari number 3 under Borhola Moza was under encroachment by persons mainly belonging to the Hindu, Bengali community and Muslim community for few years by a construction of temporary oblique semi-pakka houses and agriculture without any form of government instruments allowing them to occupy the land. Thereupon, eviction notices were issued on 15/11/2021. Asking the encroachers to vacate the government land under encroachment within 30 days or before, whichever was earlier. It was further mentioned that an eviction drive was conducted on 3/9/2022, much after the eviction notices were issued on 15/11/2021, and prior to the filing of the writ petition. Whereby three nine 22 or 3/9/21, 23. Huh?
39, 22, 22. 22, it is a typological error, my lord.
It was further mentioned that at that relevant point of time, 299 families were evicted. And out of them, 45 families were found to be landless. Under such circumstances, a rehabilitation proposal for 30 bighas of VGR land at a nearby Nisolamari village was recommended. It was also mentioned that the government, by the letter dated 4/12/2022, had approved for de-reservation and re-reservation of equal quantum of land in the same village, so that these 30 bighas of land which have been identified could be allotted to those 45 families who were evicted. It was also mentioned that after the land was made free from eviction, the lands in question were demarcated by putting barbed wire fencing. But thereby, however, by keeping at several points roads open for ingress and egress, those still residing inside the scheduled land. This court at this stage very specifically sought for a clarification as to how, on one hand, in the affidavit, it has been mentioned that the various families were evicted And then also, on the other hand, it has been mentioned in the affidavit that certain areas were kept open for ingress and egress for certain persons to move inside the scheduled land. Mr. Arbor, appearing on behalf of the Revenue Department, submitted that those persons who were inside were those 45 families, isn't it? 45 families, which who were actually landless people, and their possession has been categorically shown in the map so prepared in reference to number 3 Sitalmare. What is that? Sitalmare one?
Number 3, Chitalmari village,
Sitalmare village
under Borsala Moja
under Boso Ramosa.
of Hekenzali Revenue Circle.
To the same effect, the learned counsellor has also referred to the enclosure to the affidavit filed on 25/2024, wherein the communications by the Revenue Department for de-reservation and re-reservation of 30 bighas of land, as well as the communication of the the District Commissioner Hunitpur, have been duly enclosed. In addition to that, certain photographs have been enclosed to show how the barbed wires have been erected. This court further finds it relevant to take note of the application seeking vacation or modification of the order dated 2/3/2023 passed by this court, wherein at paragraph number 5, it has been categorically mentioned that a plot of land at measuring 864 bighas, 2 katha, 11 lechas, corresponding to 285 acres, located at 3 number Sitalmari village under Borhola Moja of Dhekiajali Revenue Circle, Hunitpur, was identified for setting up a 50 megawatt grid connected solar PV project by the SJVN Green Energy Limited under the supervision of the APDCL, with a total contract value approximately to 350 crores and an expected completion date of August 2025. It was also mentioned that the Chief Minister of Assam had on 10th of March 2024 laid the foundation stone at the project site, and the said projects shall contribute project site. Further to that, it is also mentioned that the said project shall contribute significantly to the power sector of the entire North Bank landscape of Assam. It was also mentioned that in the said affidavit that on 3/9/2022, the land in question was made eviction free, encroachment free. However, subsequently, in view of the there has been re-encroachment.
My lord, may I interrupt here, my lord? I thought I will wait, but since this honorable court has, it has started dictating after the stand, so far as that barbed wire is concerned, this picture will be clear if this honorable court sees the direction passed in the contempt petition. That was after the interim order passed in our writ petition. The barbed wire was not before.
No, this is their stand. I'm not
Okay, still
saying,
the stand.
I'm not
sorry.
adjudicating
okay.
anything.
Okay.
Are they not saying this?
Sorry.
It was also mentioned that a field inquiry was conducted by the circle officer, Dhikiajuli Revenue Circle, where it was confirmed that in the project site that was made free after eviction had been re-encroached by around 200 numbers of families. Further to that, it was also mentioned that for setting up of a 50 megawatt AC solar power project, the total requirement is around 200 acres as per the thumb rule. Setting up of 1 megawatt bracket AC solar power project requires approximately 4 acres of land. In this backdrop, this court have duly heard the learned counsels appearing on behalf of the petitioners, as well as the learned counsel appearing on behalf of the respondents. Before further proceeding on the adjudication of the instant writ petition, this court finds it relevant to take note of certain aspects which came into light during the course of the hearing. During the process of the hearing, this court made a specific query upon both the counsels appearing on behalf of the Revenue Department as well as District Administration as to where would these petitioners go if they are being evicted. The answer to the said query so made by the counsel appearing on behalf of the Revenue Department as well as by the District Administration is that the petitioners can very well that the encroachers can very well be shift to the 30 bighas of land which have been allotted in Dag number in Dag number 385 of village Nisola Mari under Moza Borhola.
That's
Moza, the revenue cycle.
Of 30 bighas of the year of 378. Huh? 378. 378 of Nisola Moza. For rehabilitation of 299 evicted families subject to evicted families. Under such circumstances, and in that regard, the Annexure 1 and Annexure 2 to the affidavit filed by the District Commissioner on 25/2024 was shown by the learned counsels for the respondents. This court have duly perused Annexure 1 and Annexure 2. And from the said enclosures, it does not show that the lands have been specifically allotted to those 299 families for whom the de-reservation process have been initiated. Under such circumstances, the question therefore arises as to whether these persons who would be evicted and if these persons are to be evicted and whether without there being an allotment assigning specific area to the families concerned, would it be possible for them to reside in that said area without any disturbance from the state authorities in future? This, in the opinion of this court, is a relevant consideration which needs to be duly taken note of while adjudicating the instant writ petition. In the backdrop of the above, therefore, let this court take note of the dispute. The question which arises before this court is as regards exercise of jurisdiction under Article 2 to 6 of the Constitution in the present facts. the materials on record, it transpires that the land in question, which is the subject matter of the present litigation, is a government land. It is also an admitted fact, as could be seen from the notices which were issued on 15/11/2021, and the admission in the affidavits to the effect that there was eviction carried out on 3/9/2022. That the land in question was under the occupation of various persons. There's also no quarrel with the fact that these persons who were in occupation of the government land have not occupied either with any permission or on the basis of any lease which was granted it is also seen that the writ petition has been filed without properly correlating the documents so enclosed to that of the petitioners with that of the petitioners. Therefore, the exact interest in respect of the rights of the petitioners vis-a-vis the lands under their occupation cannot be identified from the pleadings so made by the writ petitioners. Be that as it may, it cannot also be lost sight of that when a litigant approaches this court invoking the high prerogative writ jurisdiction with a petition under Article 2 to 6 of the Constitution alleging that the impugned state actions is in breach of the fundamental rights and claims that the breach to be breached by issuance of appropriate writ order oblique directions as distinguished from a claim for enforcement of a statutory right. It partakes the character of a duty cast upon this court to enforce the right breached as the guardians of the Constitution. The breach so alleged in the writ petitions amounts to a breach of Article 21 of the Constitution on the basis of violation of the principles of natural justice, which, as per the judgment of the Constitution Bench of the Supreme Court in Manuka Gandhi versus Union of India, reported in so and so, has been held to be a part of Article 21 of the Constitution. This court finds it at this stage profitable to take note of the judgment of the division bench of this court in the case of Mohammed Salakuddin versus the state of Assam, reported in so and so, wherein the principles of natural justice was imported to Rule 18 of the Constitution. And more particularly in respect to lands which are wastelands, as in the present case. In the backdrop of the above, this court also cannot be unmindful of the fact that these very lands have been specifically earmarked and reserved for the setting up of the 250, 350, 350,
50 megawatt.
a 50 megawatt solar project. As already stated in the previous segments of the instant judgment. And for that purpose, to accommodate these 299 families, the government had also taken a constructive decision to de-reserve a VGR land in Dag number 378, and so that these 299 families also can be accommodated. This court cannot also be unmindful of the fact that the delay in execution of the project would also entail escalation of expenses of the cost of the project. Under such circumstances, taking into consideration of the above, this court is of the opinion that a balance has to be maintained as regards the rights of the petitioners under Article 21 of the Constitution vis-a-vis the rights of the government to go ahead with its project. For the above reason, this court therefore disposes of the instant writ petition with the following observations and directions. The materials on record do not show the materials on record as placed by the petitioners do not show that they have a right to continue to remain in possession of the land which is the subject matter of the instant litigation. However, taking into account the Assam land policy of 2019, the petitioners have a right to be considered for settlement, for grant of settlement, if the petitioners belong to an indigenous class. Indigenous belongs to indigenous are indigenous people of Assam
Indigenous.
and also are landless. In that view of the matter, this court grants the petitioners 30 days from the date of the instant judgment time to submit representations before the respondent authority, before the deputy commissioner, district commissioner, Punitpur, placing on record that they are indigenous family, indigenous people, and do not have any, and as well as landless, and as such have a right to be considered for settlement in terms with the Assam land policy of 2019. In that regard, the petitioners shall also bring on record, bring to the notice of the district commissioner their individual applications so filed for settlement as per the Basundhara 2.0. Number 2. The district commissioner, Punitpur, is directed forthwith to place to issue a notice and post it in the notice board of its office, the place where the official to whom the representations so are to be the representations are to be submitted by the petitioners.
Well, my lord, I had a talk with my colleague, my lord. The circle officer is a party, concerned circle officer. We can open a facilitation counter in the circle officer office also.
Let it be the district commissioner, my lord.
I have given it. You put a notice.
Yes.
I'm not saying
Yes,
anything,
yes,
but the
madam,
decision is to be by the deputy
yes,
commissioner.
yes. We take it, madam, we take it.
But see, the district commissioner, Punitpur, upon receipt of the said representations, shall hear the shall give an opportunity of hearing to the petitioners or their authorized representative. Therefore, upon hearing, the district commissioner Punitpur shall pass appropriate orders taking into consideration appropriate orders upon hearing the petitioners, upon hearing, the district commissioner shall pass appropriate orders to the effect as to whether the petitioners petitioners are indigenous persons of Assam and as well as landless. On the basis of the said opinion, the district commissioner shall also, in consultation with the revenue department of the government of Assam, pass appropriate orders allotting certain specific area of land to those persons who have been found to be indigenous persons as well as landless persons in that area which have been specifically allotted, specifically de-reserved in dark number 378. For rehabilitation of the 299 families. You have to give a post. It is further observed that in the circumstance, no such any order is passed adverse to such petitioner, such person who submits a representation. The respondent authorities shall not take such coercive measures against the persons now. What order should I pass to that effect? Not to take coercive measures because they are not entitled to remain there. I'm only asking them, where will these people go then?
For next 30 days, because this is what.
No, where will this person go? You see, here I have categorically held that they have no right to remain in 370, that dark. So therefore, the question is, they are to be given allotment.
Allotment because one.
And allotment who are given, it's okay. But what happens to those persons who are rejected? Where will these people go?
Almost, my lord, all the persons out here are in occupation of those lands by means of doing agriculture, not for residential purposes.
No,
And it
that
not
is okay. But if you find tomorrow that a person is not an indigenous and a landless, where will he go?
He will go to his, my lord, he will have to, my lord, face the consequences. He will have to revive.
No. I have already held that they have no right to remain inside. I held that they are entitled to rehabilitation, subject to proving that they are indigenous and so and so.
Family, because my lord, the land policy spells the word family. It is
Indigenous
segregated,
family and landless.
landless. And in our affidavit.
And in the circumstance they are not, then what happens? From your objection, what happens then? How do you take care of that situation?
Because we have categorically spelled out, my lord, with all respect, my lord, that there are only, we have found only 45 families to be landless families.
What you are saying 45 families. In that order of the revenue department, you say that 299 families will be rehabilitated. What is this? Your district commissioner may say many things. I'm not concerned with that. But the fact that you have in your order of de-reservation categorically mentioned about 299 families, where will they go?
For that, my lord, the authorities will, my lord, have to take an exercise for further earmarking, my lord, appropriate parcels of land, my lord, over and above this 30 acres. That's direct, my lord.
No, I'm not on that. I am saying those persons who are not indigenous, if it is your opinion, although they may be. The district commissioner says that they are not. Where will they go?
If they are not indigenous, then, my lord,
Because you
Yes.
see, this order is a bit
Yes.
different from the earlier orders. There's
Yes.
a reason why I am saying so.
my lord, temporarily, my lord, kept in some place, my lord. Otherwise, my lord, they cannot be given allotment, my lord, because land allotment has to be done in consonance.
No,
with
no,
the
they
provision.
cannot be granted allotment. So they will be temporarily accommodated by proper orders.
Temporarily, subject to, my lord, that we are not going to take care of their, my lord, care and comfort, my lord.
No,
Care and
not care and comfort. You will be allotting
Yes.
some area for them
Yes. There
for,
were some
for
areas.
these 30 days.
Yes, for these 30 days, yes, yes. I'm so grateful, yes. Yes.
For these 30
Yes,
days,
yes.
after passing an order for these 30 days, you are not going to
Yes.
you have to allot a particular area without creating any right
Yes. It will be only for temporary, my lord,
till they file an appeal.
till they file a debit. Therefore, next 30 days. Next 30 days. So that means 30 plus 30, 60 days.
In those people who are going to be indigenous, they will be accommodated. I'm asking them to put it on allotment orders. But those persons who are rejected, just for example, for them, I'm giving them 30 days for filing an appeal against the order of the deputy commissioner. But in the meantime, where will these people go? So some temporary arrangement has to be made so that you are allotted at that particular area for this period. And this period, when they are there, you are given, and that shall not create any right on the basis thereof, but subject to later on. And if you are win later on, you'll be allotted specific area.
Yes, that 30 days is one dicey thing, my lord. That 30 days that they are.
30 days from the date of the order passed by the district commission.
I understood.
Further
Thereafter,
verification.
till 30 days, they will accommodate me somewhere. That is what they are trying to say.
These accommodation will be there.
That 30 days thereafter, I go where?
No, you file in the Board of Revenue. Against an order of the DC, it lies to the Board of Revenue. So therefore, I'm giving you, because the appeal,
It is decided it may be like this, but.
No,
it
no,
will
no,
not
no,
have
no, no,
30
no.
days.
Till the dispute is decided,
If it is one family also, let us take it that there is one family out of those 299 families. Where does that family go with the children?
the district Board of Revenue.
Yeah, so far as the litigation is concerned, so far as the proceedings will go, but where will the family go, my lord?
There's no family business out there to remain inside.
No, I'm not saying to remain inside. They are saying that they will give some temporary accommodation will be given.
They will allocate certain area for that. That is what I'm saying.
They will,
Like
for example,
those people also, who are also indigenous people also, they cannot remove you till they make the allotment.
this taken care of. I'm so grateful.
So
But
for
for
that,
example,
till they don't allot you, they cannot.
yes,
Now, as regards those who have not been there,
let us take one family.
yes, it
Just
is
one
not there. So they will allocate a proportionate area which is there earlier for that, for other people which is being given, that area will be given to you in some, allocate in some other area, temporarily, without creating any right to you.
Yeah, that I understand without creating any right from nineteen.
And then thereafter you get a stay in the Board of Revenue. But the fact that, madam, one has to also take note of, this is, I'm giving you a right so that not to evict you without giving you an allotment. Now, normally, court does not give a direction for allotment. I'm only giving it so that tomorrow, because of that document where they say that they are going to rehabilitate. So now, therefore, they are going to give an, and as making it specific, then only you shall move. Chalo.
But that temporary period, my lord, for
Ah.
30 days, my lord, we will not, anyway, yes.
No, no, I am therefore saying
Yes, yes, yes,
that
correct, correct.
don't disturb anybody till your decision and allotment. Decision shall, if you decide that yes, this person is indigenous, that order should also have the trappings of an allotment. Therefore, I roped in the revenue.
Absolutely.
I'm so great.
Okay, disposed, huh? Even that third, I'll put it. So that is enough.
Yes.
Anything else?
I'm so obliged, my lord.
Because I could have passed the similar order like that, but that is going to escalate the use
Yes,
expenses.
because there, my lord, the distinguishing factor was that when urgent need was not there. That factum of urgent need. There is a factum of urgent need, my lord. That's what.
So this is why I'm
so
saying.
grateful.
But so far as urgent, they have they are saying allocating 897, I think, because of land for that project. But there is 2,000 land, and in their affidavit they say 1,000 because of land is already there. So it's not that they
No,
can.
no, they are actually allocating 235 acres.
Acres. Oh, that's.
So they require actually 200 acres and rest is for only for laying the solar panels.
Number 32.
I'm
Number
great.
32 is the content matter. The interim order, they have realized that we have violated the interim order of 2/3/2023.
Item number 32, Lekho. You are the petitioner.
Yes, sir.
So and so heard so and so and Mr. So and so. Taking into account that the order which has been passed in disposing of the petition number so and so, the councils appearing on behalf of the party submits that the instant proceeding.
Fencing part, if it could have been recorded in the main order, that fencing, it appears in the content petition that
What?
after the interim order, that fencing was done.
Let it do. I'm not concerned with the
They are
fencing.
rights, my lord. What more is required?
I've given you arguments. Fencing, I'm not concerned because you see, therefore, I have not mentioned about, they have mentioned about 44 families. In my order, I have not mentioned, I said about 299.
One who is
But,
concerned.
but madam, very horribly drafted with petition.
Yes, my lord, with the bulldozers behind, I can understand, my lord. I am very sorry.
Number 37, the order direction. I would not like to press the application.
So and so doesn't want to press. Yes, order matters. Mr. Das, I'll take care of matter after some time. Let me complete those order matters first. One orders.
35 for orders.
Yes. Service complete.
My lord,
Yes, Mr. Pegu, what has happened to this matter?
My lord, we have already sent the,
Have you passed the award?
my lord,
Made the award?
my lord.
Have you sent it to the revenue? Yes, revenue. You have approved.
And we have resent it to the government. Sorry, Lord, may
You are the government?
yes.
Then what have you done?
No, there is some problem in the calculation. Lord, may kindly bear with.
No, no, it's okay. Why? What is the problem in the calculation? Calculation mistake can be manual. You just say that he can very well. He has the
Yes,
power to do under 13A. So why you are not approving it subject to saying that this is the calculation
No, we
mistake?
have sent it and they have the power. Now, as per their, if there is a one document.
No, this is done under the 18, this will be the 1894 Act. The proceedings are all, only the compensation is done under the 2013 Act.
Good.
All other provision is under the 1894 Act.
Yes.
So under such circumstances, when it is the 1894 Act, you have section 13A, whereby these arithmetical calculations can be corrected by him. So have you given the approval subject to that?
Yes, that is been given.
Approval given, then what happened? Have you filed it? Filed the award in your office?
After filing our first estimate and award, my lord, yesterday we have received a copy, my lord.
So
some
you
corrections
filed
has
the
to be
award?
made,
You file the award under 12, and then file an affidavit bringing on record that the award statement was made to them. They have given the approval subject to some calculation. Calculation mistake corrected under 13A, and then award filed under section 12. Then bring in, put it on affidavit. We catch hold of them then.
And there is one more aspect. There is a notification of 7th of April 2022, whereby the power of this appropriate government has been relegated to district collector. So no prior approval is required now.
So then it is not required. He can almost file it.
I will send it directly to the department, ma'am, required department.
No. You pass it. Then you tell him that this is the award we have passed, kindly make the payment. Then we catch hold of him. Mr. G. Pegu and Mr. G. Pegu submits that the award statement has been prepared and then sent to the revenue department. Mr. Ebhachaji, appearing on behalf of the revenue department, had submitted that the award statement contains certain certain clerical errors which have been approved subject to making those corrections. Mr. G. Pegu, the learned counsel, appearing on behalf of the district the collector, submits that upon due correction being made, the same is going to be filed in a day or so. To establish this matter again on 10th of January 2025. In the meantime, the district collector, Dhemaji, is directed to bring on record the above aspects by filing an affidavit.
36.
See, madam, that is the problem when you pass an order, the filing writ petitions out here.
Item
Yes.
36.
Respondent number 5 address.
I am for the respondent number 4, my lord.
And appears on behalf of the petitioner, matter stands adjourned to be listed. Oh, okay. None appears on behalf of the petitioner on call. It is seen that the respondent address of the respondent number 5 has not been provided by the petitioner in spite of various opportunities being granted. So, as a final opportunity, this court directs the petitioner. What is this matter about? Muslim marriage and divorce. What remains nowadays?
Qazi allowed divorce, my lord. They challenge this divorce, my lord.
Okay. Taking into gives a final chance to the petitioner to provide the address of the proper address of the respondent number 5 within by 6th of January 2025. So if it is not so provided, the matter be again listed before this court.
Objection. 7 and 38.
Yes. You are being for respondent number 2.
In the contemplation for the respondent, my lord,
You file your affidavits.
we have filed the affidavit, my lord. We have also filed a review petition. We will also file a review petition, my lord. The second item is the review petition.
Who has passed the order?
The Honorable Justice Ujjwal V.I. has passed.
Let me
number 7.
dismiss it. Let me dismiss it. Ask also the Chief Justice to dismiss it, then go to the Supreme Court seeking review.
But, I'll submit, my lord.
Hello. You want the review petition?
Yes.
What is the review order?
My lord, kindly come to page 17, my lord. 28/1/2019, there is an order.
What is the direction?
Direction is to, my lord, considering the land measuring about 3 biga, to make the payment of compensation, my lord. Page number 22, my lord.
4 months from the date of receipt of a certified copy. Needless to say. Yes, what is wrong?
My lord, in this writ petition, my lord, in fact, the affidavit in opposition was not filed by the government, the deputy commissioner. But subsequently, in the contempt petition, while we are searching for the record, in the Sadar Sabapati, my lord, we have found that the petitioner has already sold so many portions of that land, and the 3 biga 15 lesser land, actually he is not entitled for. He is entitled for only 4 katha 10 lessers of land compensation for 4 katha 10 lesser land. Rest of the portion he has already sold during that time.
Mr. Sakya, have you filed your affidavit
My lord,
in the review petition?
I will file a reply to the review petition, but however, Lordship may kindly see the review petition file is there, record the call for review petition number 4507 of 23, where they
No,
have
no, no.
admitted.
Are you filing an affidavit in opposition to the review petition or
I
not?
will file.
Mr. R. Sakya, the C. Sakya, the Lone Senior Counsel submits that submits that he would file the affidavit in opposition to the review petition. This matter for 4 weeks.
Problem.
39. Yes, will be listed after vacation, my lord.
4 weeks.
Problem.
39.
Why you're not taking steps upon respond number 6 and 7?
Probably petitioners may not even press the matter.
Okay, you don't want to press.
Should be not 1 week time because.
What we can, you don't appear in the matter whenever it is called earlier? No steps taken upon respond number 6 and 7. What are you challenging?
Even copy not served, my lord.
Huh?
Extra copy not served.
Extra copy is not served. Okay, 50,000 cost upon the council for the petition.
Matter is already old, so.
No, 50,000. That day I have imposed one cost like this. You cannot do all this.
Also, we have lost contact with petitioner itself, so.
What?
We have lost contacts with petitioner. We have not.
Then? And what do you want? What is the challenge here?
Case is that, my lord, they were earlier elected, my lord, as ward members. And after, my lord, the 2018, the new panchayat came, my lord. They have changed their schemes. Some after holding the Gram Sabha. That is their grievance.
Now, lordship, for long, many years, petitioners have.
Who are they?
They were earlier ward members.
So are you a ward member now?
No, my
That is why we are not sure because only terms are about to
at
expire.
present, my lord, no one is
Set
there.
aside the
Jurisdiction is
improved
about
stuff
to.
that is under the 14th Finance Commission. My goodness,
Already terms are about to expire, lordship.
Already expired.
No,
it has already expired.
petitioner maybe not even in the committee because panchayat elections are.
Period over.
Period over, my lord. Now about
Nothing
to,
All this person doesn't mean.
That has almost become infectious.
We close it.
yes. Nothing survives.
It is seen that the petitioner have not taken steps or effected service upon the, have not effected service pursuant to the notice so issued by this court on 17/2/2020. In addition to that, steps have also not been taken upon the respond number 6 and 7. The case before this court, the appraisal of the petitions show that the petitioner have a say the impugned list of scheme under the 14th Finance Commission grant for 2018-19 published in the official gazette of the department against Mohammadpur Joy Krishnapur Gram Panchayat, as well as also the impugned list of scheme prepared and submitted on 26/8/2019 and 11/12/2019 by the respondent number 6 and 7 under the Amar Ansoni under the 14th Finance Commission for the year 2016, 17, 17, 18, 18, 19. Full stop. It is seen that the period in question have already expired. And as such, nothing further remains in the petition for which the petition stands closed.
Obliged. Hello.
40,
You're filing affidavit, complied.
in this
And-
case, your lordship, as per the,
What, you have got the money?
1 lakh, your lordship, as per the
Old
That-
scheme.
whole scheme, but as per the direction, it would be considered as per the new notification, your lordship.
Why?
Because, honorable court was directed,
Falls under the old school.
When did you die?
in the year of 2023, 13, your lordship.
At that time, that notification did not come.
But, they are not.
Lordship may kindly.
Okay, we do one thing. You want that, no? The new law should apply. Are you saying that?
As per new notification, your lordship.
And are you saying that the new law should apply? If you say that the new law should apply, we apply Justice Surana's judgment. You want that?
Because,
Ah,
order is first earlier.
Ms. N. Bodloy, appearing on behalf of the respondent, submits that the order has been duly complied with, taking into account that the amount of rupees 1 lakh have been duly disbursed to the petitioner. In that regard, she has placed certain documents which is kept on record and marked with the letter X, taking into account the above, the instant contempt proceedings then dropped.
So, obliged.
Pleasure.
Huh?
41.
No, where is the contempt matter? Principal, read petition, is there? 41.
41 also, your lordship, the petitioner, she had married one person, your lordship.
Huh?
Petitioner is. You may kindly have a look.
But you are not paying that amount.
She married someone else, your lordship.
Who?
Details are there, your lordship. This contempt case has been filed after she got married, your lordship. Married in the year 2020, and the petitioner's husband died in 2015, your lordship.
The direction which has been passed on receipt of the sanction of remand shall take necessary steps towards disbursal of the same amount to the petitioner. So this is the problem, na? You file it by way of an affidavit. Then Bodloy submits an instruction dated 18th of December 2021. None, however, appears on behalf of the petitioner or on behalf of the contempt petitioner. List this matter on
First week of February.
21, 2025. 2025. In the meantime, an affidavit be filed bringing the notice of this court, the instructions.
Also, your lordship, the respondent contemner is no longer holding the office. MS Money.
Not necessary, whoever it is, file it. Just bring on record that thing, because then I can close it
42.
or direct them to make the payment. Because without that, to do it properly.
We have taken steps and filed an affidavit for justice service on respondent number 2, as per the previous order.
40?
42. There was an
Eh, শুনো। 42 নাই কিয় ইয়াত? ক'ৰবাত আছে নেকি চাওকচোন। এনেকুৱা হৈছে ক'ত contempt আছে, contempt ক'তো নাই। Yes, you have taken steps.
and filed an affidavit to that regard.
Yeah.
On respondent.
Mr. B.J. Mukherjee, appearing on behalf of the petitioner, submits that that the petitioner have taken steps by way of dusty and filed an affidavit of service Also, this court had dated 19th of September 2024. Also, from a perusal of this court had duly perused the said affidavit, and from a perusal thereof, it is seen that the service have been duly meted upon the respondent number 2. So accordingly, the service upon the respondent number 2 is deemed to be complete. 2 na? Is the service now complete?
Complete.
Taking into account that the service is complete, leaves the matter for admission. What about 4-5? Complete.
is represented already.
Okay. Taking into account the above, the service leaves the matter for admission immediately after the winter vacation. Then
Forty-seven.
My lord, private respondent number 5, 6, 8, and 9 made appearance except 7. I may be permitted to take steps on private
why
respondent.
don't you take the steps when the matter is before the Lozima court? Well, you don't have time for that.
This is my mistake, my lord.
Okay, 50,000 cost,
Today I
Better.
will go. Tomorrow I will take steps.
5,000, minimum 5,000.
Excuse me. And they are
5,000 cost
they
has
are
to be given.
old person, my lord.
The old person,
Private person, my
you have money. I'm not asking him, the petitioner, to give you. For upon you, the cost is.
for one day. Tomorrow I'll definitely.
The counsel appearing on behalf of the petitioner submits that fresh steps would be taken upon the respondent number 7 by tomorrow. List the matter again on the registry shall list the matter again before this court if no steps is taken by tomorrow.
Interim order earlier plus may kindly.
Absolutely no. In time order, I'm not continuing unless you take steps. Sorry.
48.
Service complete.
Service for lordship in respect to respondent one and 2 have filed their affidavit, your lordship, and 3 also it is shown as complete, your lordship.
Service being complete, list the matter for admission in its after vacations.
Actually, I'm appealing for respondent number 7.
Huh?
Appealing for respondent.
7.
49.
What do you want to say? 49. 49 is respondent number 7 is there.
48.
48 only service was as regard respondent number 3. That has been done. What about 49?
In my lordship, this matter has become infructuous.
Infructuous?
Lordship.
None appears on behalf of the petitioner on call. Mr. Ibotakur appearing for
Forest Department.
Forest Department submits that the writ petition has become infructuous in view of
The environmental clearance, which is under challenge, has already expired, lordship.
in view of the fact that the environmental clearance, which is the subject matter of challenge, has already expired. The above therefore appears it therefore appears that the petitioner have lost interest in the writ petition for which the writ petition has is dismissed for non-prosecution.
Obliged.
Then
Step 43 left out.
Please, your lordship.
Hmm.
In this case, my lord, writ petitioner has expired in the year 24/10/2024. Hence, appropriate application has to be filed.
Counsel appearing on behalf of the petitioner. Counsel Mr.
S. Rabha.
S. Rahaba submits that he was a counsel of the petitioner who expired on 24/10/2024. He therefore submits that the legal representatives have duly informed him to take appropriate steps. List the matter of the 6 weeks.
Obliged.
51.
Service complete?
Complete.
Service complete. List the matter for admission after the vacations.
I'm appearing for your lordship for,
Have you filed your affidavit? Then don't make us a statement. We are in the orders matter. Next.
52.
None appears. None appears on behalf of the petitioner on call. Oh. List this matter for no, the petitioner is given a final opportunity to take steps upon the respondents upon 2 to 8. List the matter on 10th of January 2025 if no steps is taken.
53.
But I have to take steps on respondent number 4 and 5. And Lord, there is one typographical error because of that, Lord, respondent number 5 name has appeared twice. So, Lord, the Lojima court has placed the matter before your lordships for passing an order for correction, Lord. That's why I can take steps.
I want to file an IE.
I'll file, Lord, if you have fresh, Lord, new cause title, Lord.
We will take new steps, fresh steps.
Fresh step as well as new cause title because respondent number 5.
Mr. R. Dubey appearing on behalf of the petitioner submits that the petitioner would like to file a fresh memo of parties taking into account that there has been a duplication in the name mentioning of the respondent number 5.
Fine.
Full stop. No, there has been a duplication of the serial number in mentioning of the respondent number, the serial number 5 in the array of the parties of the respondents.
I'll take
List
steps
the matter after 4 weeks.
And Lord, I have to take steps after ascertaining the new address because I had said that permission
54.
also, Lord.
Yes, what do you want? Interim order praying for direction to respond to allow the respondents to renovate the house.
I am for the petitioner, Your Lordship. I am for the petitioner.
Who has filed the work
Respondent
application?
number 4, Your Lordship. Respondent number 4.
Okay, none appears on behalf of the respondent. Respondent number 4 oblique the applicant who has filed the application. List the matter after vacations.
Obliged.
55.
But may I pray that this matter may be taken up in the first week of January for dismissal, my lord. Similar issue has already been decided by your lord.
What is that?
Practically, it's another stretch of 3 kilometers. Same,
Same.
absolutely similar facts. They submitted their bid at the startup partnership form when they were told to produce
that
after
one?
registration a certificate.
So may I
It's
pray
another
that
stretch of 3 kilometers.
dismissal in the month of first week of January.
So he doesn't want in the last week. He wants to have a lovely Christmas and then followed by a good Mag Bihu. So we have it just on 20.
I understand.
Let him enjoy.
I understand he's right wing. So Christmas may not really give him great pleasure.
There's a stay operating.
There's no stay, but will not stay in the sense that without leave of the honorable court, we cannot award contract.
Oh, that is delay. So list this matter on 7th of
Yes,
January
7th.
2025 in the column of stay vacating.
Supplemental list 67.
You have filed it? Okay, they have filed some affidavits out there. I've asked some PCB to file some affidavits in this matter. Have they filed it?
Petition board, my lord, has filed the affidavit. But
As regards the updated status pertaining to these fair persons, have they filed it?
Petition board.
Huh?
Petition board. But he is not present in council.
Okay. Okay. This, the pursuant to the order passed by this court on 18/12/2024, the memo parties have been duly submitted. No, passed the order on 17, na? What 2011? I passed the order on 17, 17/12/2024.
Order was passed on 16, that they were supposed to file by tomorrow, yesterday, my lord.
Okay. On 16/12/2024, the petitioner have already filed a fresh memo of parties, thereby deleting the name of the respondent number 27. Full stop. List this matter for admission immediately after the reopening.
Matter will be, date may fix, my lord, because my lord, we also filed the latest information as to the pollution clearance, my lord. And the government has also filed the affidavit, my lord. Yeah, the date may fix, my lord. All pending matter 2014, my lord.
22nd of January.
My lord, deeply of
68.
Yes.
By common judgment, lordship.
Well, what do you mean by recommendation and ratification? Tomorrow, can the UPSC say that, okay, let the government appoint those persons as appointment and we will ratify it that their appointments are okay?
In this case, what when on the day of
Can tomorrow the government say, okay, we are appointing these judges, the recommendation to be made by the Chief Justice or whatever can be made later on. Can it be done?
Sir, no, that cannot be done. But here in this case, lordship, what happened? When the lordship heard the matter, before that, lordship, it was already.
What? But can a recommendation take the role of a ratification? Ratification is approval.
No, yes, correct, lordship.
Can there be an approval? Ratification means approval, that we approve. So with a ratification, can you take care of a recommendation? That is the question.
Here, what happened? The law committee has issued the notification 56 of 2023, extending the time limit prescribing notification 9 of 2023. This aspect of the matter could not be placed before the your lordship.
No, I understand everything, but the question arises: can by way of a ratification, you can say that okay, by ratification we do away with the recommendation?
No, that simply that cannot be.
That is your subject matter of a review.
May please to see paragraph. Paragraph 7. Paragraph 7 of my review petition.
Yes.
Lordship 7A. The agenda note dated of that section 73 of the GST Act 73 provides that the proper officer shall issue the order demanding any tax that has not been paid or short paid or erroneously refunded, or where input tax credit has been wrongly availed or utilized for any reason other than the reasons of the fraud or any willful misstatement or suppression of fact to evade the tax within 3 years from the due date for furnishing the annual return of the financial year to which the tax is not paid or short paid. Then B, it is further stated that as per notification 9 of 2023, central tax dated 31/3/2023, time limit specified under section 10 of section 73 of GST Act for issuance of order under subsection 9 of section 73.
No. Your ground is that this was ratified as on later on 22/6/2024.
Yes, sir.
Which was after that. Therefore, my question is, can by way of a ratification you do it? Mister, I have given you the what liberty. Kindly see
Yes,
my
lordship
order.
has given liberty.
Why you are not exercising that? 168(2).
That is there. But
Why you are not taking that? You can very well. 168(2) gives you power to go for retrospective.
Another aspect, lordship,
Can't ratify.
another fact, lordship, this notification 56 was upheld by the Patna High Court after passing of the judgment by your lordship.
So what? I'm not bound by the Patna High Court, neither Patna High Court is bound by me.
No, lordship,
I'm
that
not
is correct.
concerned with
But
that.
Same notification.
So what?
You may hear the matter like that from some other.
No, Patna High Court does it. I'm not bothered with that.
No, lordship.
I'm concerned out here. My order is there. You want to file an appeal, go and file an appeal. So where is the question of review?
Because we filed because on the day when the judgment was passed, these facts could not be brought before your lordship.
So that I duly take note of, and we dismiss it on the ground that nothing remains, that the ratification cannot take the role of a recommendation. Dismiss this review petition. Go and take it on appeal. Let us do it in the reopening.
It'll be better.
Huh?
On 6th or 7th also.
7th. We take it up on 7th in this. Patnaik, what does he say?
Lordship, both the notification 9 and 56 has been upheld. And your Lordship's order was also placed before the court is respectively, we are differing with the order passed by the Guwahati High Court. And
On the ground of rectification.
no, Lordship, because all these things were placed, court has considered that Supreme Court judgment, where the limitation was extended. Mainly that ground it was taken. The authority has power to extend the time limit.
On the ground of limitation, without a recommendation.
Recommendation, they have also taken note, but they said that limit.
Have they stated that there is no recommendation necessary?
No, that is not.
Then what is the basis? There they have taken note of that. Anyways, we'll have it on 7th.
Yes.
For dismissal. It's the matter on 7 for on 7/1/2025.
Item 3 fixed it.
Do? Item 3. Yes, Mr. Didas, your matter.
Item 3.
I have checked the GM portal. GM portal says that that's the corrigendum is required. GM portal. That's I was, because I didn't knew, your lordship indicated. See that GM portal, your lordship dealt in one of the, as a lawyer, and said GM portal. We have checked and found a GM portal request a corrigendum.
For change.
Yeah, change. Total change. Corrigendum. But we got.
You got
a
it
bunch
by
of
filing an affidavit?
We'll file it. If necessary, we'll file it.
You filed an affidavit? No, you have
No.
not filed an affidavit.
No.
Bring it on record.
No, it is GM portal.
In the GM portal, bring it by way of that is why I gave you the opportunity last time to file.
I thought that I will just produce it.
No, you file an affidavit saying that is not, because that is her basic case. Then look here, we made a mistake by putting it at as a clarification, and therefore now people will think that we are doing some favor to somebody.
Yes.
Although you want to go back to the first, whereby they are otherwise
Yeah.
qualified.
Yes.
So you therefore say that the GM portal does not, when it is done it has to be mandated in that manner.
But in
Yes.
fact, it is there in the, my lord, general terms and conditions as well as in the general financial rules also. It will have
Bring
to
it
be
on
modified.
We actually,
by publishing, yes.
File your affidavit, we'll
that
have it
was-
on, we'll have it on 7th.
Yes, yes, that was indicated.
Is the matter on 7th? In the meantime, an affidavit be brought, additional affidavit be filed by the petition.
That is given as part of the lordship.
Already shown as part of.
My lord, there is an interim judgment. There is a-
Thing is there.
Yes, yes.
Yes, there is a-
Interim order is there. That's why your lordship wanted to take up the matter.
Yes.
But there is an interim order.
Same order passed earlier shall continue till the disposal of the petition. Yes, what is your matter?
69, my lord. 69 ATM. This lordship as per early that is ordered dated 26/11/2024. Kabi Anglong is to file and he is to file affidavit. That is status. They have filed affidavit. They have filed affidavit stating that, my lord.
My lord, no copy was served to me
Yes.
till now, my lord.
Some of the petitioners not affected and other petitioners who are left, they have given.
You have filed affidavit.
Yes, no, sir, we have.
No copy given to
Kabi
him.
Anglong has
Not
filed.
given, my lord.
Not copy given here to him.
I checked the notice
How
also,
can-
my lord. There is
How
no
can the filing
signature.
be accepted? This is the filing report, lordship.
Okay, Mr. B. Bulwer, the learned counsel appearing on behalf of the petitioner submits that though an affidavit has been filed on, when did you file the affidavit? 17/12/2024.
No, we have filed on 3/4.
Huh?
17/12, lordship.
17/12/2024. However, no copy has been served upon him. To establish this matter again on 8th of January 2024 at 2 p.m. in the, along with the said affidavit.
Take the
8/1/2024 at 2 p.m.
25.
I'm waiting for my lord. That is a hearing matter, my lord. Petitioner is also here, my lord. I am appearing for respondent number 6, my lord, who died, my lord, as per my information, my lord. My lord, I have no contact with my client, my lord, but I have received this information, my lord, through other source, my lord. May petitioner may verify, my lord. My lord, I have to inform the court because it is.
Mr. G. Goswami appearing on behalf of the learned counsel submits that that the respondent number 6 for whom he represented had expired. So the petitioner shall make necessary verification and do the need.
Deeply.